Hear ye, hear ye, hear ye. All persons have anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
All right. Good morning, everyone. The panel today consists of myself, Ariane Vuono. To my right is Justice Peter Rubin, and to my left is Justice Maureen Walsh. We have 6 cases on for today. We're going to take a short recess after the 4th case, about 15 minutes or so. I see a lot of people here who I've seen before, so you know the rules of the court. Each person has 15 minutes to present their argument. I always like to assure everybody that we've read everything that you've provided to us, so you can get right to your most salient points as soon as you can. You don't have to use your entire 15 minutes, but you're welcome to a full 15 minutes, and there is no rebuttal in the appeals court. With that said, I'll call the first case, Commonwealth versus HARLEY Lambert Jr., 2023-0825. Good morning, Counselor.
Good morning, Your Honors. Your Honors, the issue in this case is whether or not the trial court can deny the defendant a hearing on a motion to suppress after he's carried his burden under Rule 13 of Mass Rules of Criminal Procedure. The district court in this case was correct in one point. The affidavit is self-serving. That is the point. Every affidavit is self-serving. It is this self-serving affidavit that provided the facts necessary for the courts to understand what evidence would be provided and for the Commonwealth to know what their burden would be to show. Now, the defendant's burden is to establish facts necessary to support the motion. In this case, that the officer failed to knock and announce as required by law and has been so since the 17th century England. The purpose of Mass Rules Criminal Procedure 13 is to put the judges on notice for the anticipated evidence and the Commonwealth on notice of specific facts relied on in the motion. The only issue is the sufficiency of the affidavit. And even if the affidavit's insufficient, it is an abuse of discretion to deny the motion raising a constitutional claim. Now, the Commonwealth, in their brief, cannot cite a single case that stands for the premise that the district court judge can deny a motion based on a self-serving affidavit. Cases that were cited, Tremblay, for the premise that questions of credibility are the province of the motion judge who had the opportunity to observe the witnesses. In that case, there was a hearing. The judge had the opportunity to observe the witnesses. Yessel-Simon, on a motion to suppress, the determination of the weight and credibility of the testimony is the function and responsibility of the judge who saw and heard the witnesses. A hearing took place, unlike this case. Moon, D'Onofrio, all had a hearing.
Let me ask you a question. What do you think we should make of, if anything, about the fact that this was not the first motion to suppress and that this issue came about 9 months after the second motion had been filed?
Sure. Twofold. First, as the Commonwealth is hanging their hat on discretion, so will I. The court had the discretion to at least entertain the motion. But more importantly, a suppression motion can be heard again if there is a colorable claim, if something new can be provided that was not known at the time of the original motion. As you can see in the docket, on that Four Corners motion to suppress, after it was denied, a motion for discovery was then filed. That discovery motion was for the body-worn camera. After that time, the body-worn camera, or the Commonwealth told the defendant there was no body-worn camera. Mm-hmm. It is our position that the existence or lack thereof of that body-worn camera is a fact that was not known at the time, which allows for this colorable claim.
Wait, I'm sorry. There is, in fact, body camera footage?
No, there's not. Which again.
And why does that make any difference? This is a motion saying there was no knocking and announcing.
Sure.
Wouldn't the defendant was there? Wouldn't the defendant have known that? Maybe not the legal consequence of it, but have known that happened the day it happened?
Correct. If we pretend for a moment that we would get our hearing, as it stands today, we all know how that would go. The officers would get on the stand, they would say they knocked and announced. 5 minutes later, the hearing would be over and we would be denied. It was our position that if we get the body-worn camera, we can provide Well, first of all, we can know whether we even have an issue there, and we know whether or not we can impeach the officer's testimony based on that body-worn camera footage. It is that footage, or once we knew the lack thereof, that was the basis for our motion, or the fact that we did not know or could not prove that led to the colorable claim for this motion.
So you're saying that you knew about it because your client told you, but until you were able to determine that there was nothing to corroborate it, you didn't want to bring the motion?
Yes, I do take issue with the word no, because I can't prove that at that time, or I can't, I can already predict how that motion will go, as it would go right now. But if I wait and there are body-worn cameras, now I can prove it beforehand, or have any sense of proof or impeachment evidence should that motion come. I don't think that I should be required to file that motion beforehand unless I have.
Well, generally, there's a reason why people file motions with all the potential reasons for suppression. It's just the interest of justice and the efficiency of the courts. And so it's not as if you're required to do something that you can't do at a certain time. There's just a sort of general rule to push things along.
Sure.
Yeah.
Counsel, curious, how long have you been a trial attorney for?
Since 2008, so.
So I would just caution you, having been in the trial court myself for many years, judges don't take 5-minute hearings and then stamp on constitutional issues an absolute agreement at whatever the police officer says, which is what twice you've intimated to this court, that you could predict what was going to happen and that after 5 minutes the police officer would the case would be, the motion would be denied. It doesn't work that way, I would tell you that. And I hope that in your future 40 years probably practicing, since you seem to have a good career ahead of you, that you'll be open-minded enough to believe that justice is being served and that the evidence is being weighed and constitutional violations are taken seriously. I think you have a strong argument here. I think you weaken your argument when you make those types of allegations.
And I understand, Your Honor, and I appreciate that, but respectfully, that's exactly what happened here, in less than 5 minutes.
Well, this isn't what we're, the point isn't, I can't say what every judge does or doesn't do. What the judge is supposed to do is, with an affidavit like yours, hear both witnesses and make credibility determinations, and one at least likes to hope that they would do so in a straightforward and honest manner, of course. That helps your case, though, doesn't it? I mean, if you already know what's going to happen, then why have the hearing? I thought your point was you've raised a question that requires a credibility determination, and that therefore requires an evidentiary hearing. That strikes me as a strong argument, as my colleague Justice Walsh says. So I don't really understand the point of you know what's going to happen.
And I apologize for derailing the issue momentarily, because it's not about whether or not, why we're here is not about whether there was or was not a knock or announce. It's whether or not the court has an obligation, once the defendant has carried their burden, to weigh the evidence. And that was not done here.
Was this the third motion?
This was the third motion, yes. There was this was the amended second motion.
But the second motion hadn't been heard yet. There was one motion that had been heard.
Correct. There was a four corners motion heard, and then what was...
No, I just want to make sure I understood procedurally. This was the third motion. I still understand your argument, but I just want to make sure I have the facts right.
Now, the Commonwealth cites Brisson for the premise that it is the defendant's burden to show whether there was a knock and an announce. First of all, my point is that that's not the issue here today. But even if it were the issue, the standard in Brisson is a warranted knock and announce, but uses the reasoning in Gomez, where a no-knock warrant was authorized. Since that case, only 3 times has it ever been cited, and only once for that premise. And in that case, which was a Middlesex Superior Court case, Acevedo, 1997, Mass. Super Lexus 345, and it was dicta in the case. Second, Brisson stands for the burden of persuasion, not as of establishing the issue. It is the defendant's burden to establish through that affidavit that there is a colorable issue to be litigated.
Can I interrupt for a moment?
Sure.
The issue really is whether or not your client was entitled to a hearing based upon the affidavit, right?
Yes.
Okay. So if you, for a moment, just a moment, follow the Commonwealth's argument that the judge has an inherent authority and discretion to filter and to say, self-serving or not, that this affidavit was insufficient to get you to the hearing, evidentiary hearing, right? Versus credibility determination being made on the papers. What more would you have to put in the affidavit? I'm going to ask the Commonwealth the same question. What more would you have to put in an affidavit when you allege a no-knock violation that would get you to a hearing?
Respectfully, I think the court is incorrect, and I would be back here based on Santa Suaso. Even if it's insufficient, if the purpose of the rule has been satisfied, then I'm entitled to a hearing.
Correct. So notice to the prosecutor, notice to the judge, right? I agree. So if inherently the judge, by writing self-serving and denied, if we could interpret that to say you didn't meet that notice to both sides, what else in the affidavit could you possibly put in to get you to that hearing?
That's an excellent question. I have no idea. Now, the Commonwealth also cites Glacken for the premise that a judge can credit or discredit an affidavit, but that hardly can be compared to this case. That was a motion for a new trial. In fact, a significant amount of the Commonwealth cites are for motions for new trial when they're arguing that the trial attorney has the right to credit or discredit these affidavits. In Glacken, it was a case 7 years after the trial concluded. The defendant filed his own affidavit to argue that his defense attorney did not read him or explain to him the rights that he was giving up. The judge in that case, after a hearing and after viewing the defense attorney's affidavit, discredited the defendant's affidavit. Again, a balancing test took place, unlike here where absolutely no balancing test took place. The Commonwealth also cites Freeman for the premise that a motion judge is empowered to discredit an affidavit even if there is nothing in the record directly disputing it. What that quote actually says is a judge has the discretion to decide a motion for a new trial without an evidentiary hearing where no substantial issue is raised by the motion or affidavit. Again, motion for new trial, apples and oranges to this case. Again, in this case, a substantial issue was raised. Now,
could the judge allow the motion, your motion to suppress without a hearing?
Can a judge allow the motion without a hearing?
Same motion that you filed. I'm the judge in a busy court. Can I look at that affidavit, take a look at the motion, and can I just allow the motion to suppress based upon the papers?
If the police report is viewed as an affidavit, then there's a weighing that's taking place. The police's affidavit or their police report and my client's affidavit. In that case, I guess I would argue that, sure, they could grant it. The judge could grant that motion to suppress because there is a weighing taking place.
So the judge in that instance, your position is, could weigh the credibility of the affidavits and without a hearing make a ruling, just not against you.
If that police report is viewed as an affidavit, I don't believe that it is.
Okay, so if we don't view the police report as an affidavit, we have your affidavit, which the judge believes, can the judge mark the motion allowed?
The burden at that point has then switched to the Commonwealth. So in that instance, the defendant has carried their burden. If that is what the judge decides, I'm certainly not going to argue it against it. I don't know that they should be able to do that. But
Seems to me it shouldn't be outcome determinative.
I'm sorry?
Seems to me it shouldn't be outcome determinative. It should be that if judges can't weigh credibility in affidavits, they can't do it for either side.
I don't know how you can weigh the credibility of an affidavit of a defendant based on the 5 or 6 sentences that are there. What are you taking into consideration? What is the judge viewing? What are they hearing? All they're reading is one sentence. That doesn't seem to be a fair balancing of what's in front of the trial judge.
So evidentiary hearing for either side if credibility is at stake.
Absolutely. Now, the Commonwealth, in the second part of their argument, claims that we shouldn't be allowed to be here because we haven't provided the necessary hearing. I only have 10 seconds left, so all I would say was that there was no transcript, there was no hearing. So
I think they're referring to the argument, whether was anything happened at the actual hearing. Was there any, well, we don't know, right? We don't know if there was any discussion about what a proffer, about what would have been developed at a hearing or anything like that.
all we have what is written on the motion from the trial.
But there was a hearing before the judge, and there was, when you say there's no transcript, that there is a recording of a hearing, correct?
Attorney spoke, yes, but there were no witnesses. A pretrial hearing was conducted, but not a motion to suppress hearing.
Was anything with respect to a potential hearing, and were you at that hearing?
I was, yes.
Was there any discussion whatsoever about why you wanted an evidentiary hearing on this motion?
Not any more than what was in my written motion.
Okay. Thank you. Any further questions?
Thank you.
No. Thank you. Good morning.
Good morning. May it please the court, Jacqueline Martinelli for the Commonwealth. I'm asking this court to affirm the motion judge's decision denying the defendant's motion to suppress. I'd first like to start with that the defendant here has failed to provide an adequate record for appellate review by not.
Were you present at that hearing?
I was not, Your Honor.
Do you have any reason to believe that there was something at that hearing that would be relevant to our review of this appeal?
Yes, Your Honor. I did pull the FTR recording of the hearing prior to writing my brief. And there were arguments made by the prosecutor to the judge regarding first discussing how there was a motion to suppress, four corners motion argued and denied, and that the second motion to suppress that was filed, the defendant claimed that he was not provided with the copy of the search warrant during the execution of the search warrant. The prosecutor then said to the motion judge that he had provided counsel with copies of the search warrant inside the home during the execution of the search warrant. So all of that information was in front of the judge prior to her making that decision to deny the motion.
Well, I have to ask, if you think that it would have been relevant for us to actually have a transcript of that, and you being an officer of the court and employed by the Commonwealth, couldn't you have provided us with that?
So Your Honor, the rule is clear on.
I know the rule. We know the rules. I'm just talking about practicality.
And yes, Your Honor, the Commonwealth could have provided a transcript, but however, the rule does state that it is a defendant's burden, and that is basis alone to deny, to affirm the motion judge's decision.
I don't really see how the record is inadequate here. We have an affidavit. Our question, regardless of what was said by lawyers, there was no evidence taken. Our question is, does evidence have to be taken? Now, maybe if they waived the argument, if they stood up and said, like, well, we withdraw our motion, that might be something, but no one's suggesting that. So can you get to the merits, actually, of the, if we get to the merits, what do you say about the argument that there ought to be an evidentiary hearing? Has to be an evidentiary hearing.
And just so I'm not confused, Your Honor, the merits of what was relevant at the hearing for the transcript?
The merits of the appeal.
Of the appeal. Mm-hmm. So, Your Honor, in this case, the defendant has failed to meet his burden under Rule 13 because he motion judges have the discretion to discredit an affidavit in its entirety.
How?
And I would point
How are they supposed to do that?
So I would point to cases, understanding that, as counsel pointed off, the cases that I cite are motions for new trial, and understanding that a motion for new trial and a motion to suppress have different standards. However, they still both have in a process that has to be conducted by the judge to evaluate the merits of the claim to see if the defendant is titled, has met his burden to have an evidentiary hearing.
But it's an entirely different scenario. When a judge is reviewing a motion for a new trial, the judge also relies upon his or her own, usually, memory of the case itself, and many additional factors. And in this case, that doesn't exist.
Yes, Your Honor, and I would, and I agree, and I would note that in cases like this, when multiple motions have been filed, I would point just to Rule 13 itself, where grounds not stated which reasonably could have been known at the time of the motion is filed shall be deemed to have been waived, but for a judge for cause shown may grant relief.
But the judge didn't say that. The judge didn't say it was waived. The judge just said that she didn't believe the affidavit.
Yes, Your Honor, and I would just note that this court could affirm on alternative grounds if the record supports it.
Well, let's just stick with the affidavit for a second. For example, so all she had in front of her was an affidavit. The statement is made. She says, by saying it's self-serving, I interpret that as meaning that it's not credible, right? Mm-hmm. So what do we do with that affidavit? It's just an affidavit. We're in the exact same position as the motion judge to take a look at that affidavit.
Well, I think that this court can give deference to the motion judge in this scenario, given that the motion...
He didn't see the witness. There's nothing to give deference to.
So, yes, Your Honor, but the motion judge did have the opportunity to observe the defendant in court. There are cases that cite...
We don't even know that.
Observe the defendant doesn't strike me as a good way to judge credibility. Maybe put them under oath.
Can I just try a different tack? So you're the Commonwealth, and you stand up in court, and the claim is that on a motion to suppress, I didn't consent to the search of my car. And I'm a judge, and I have an affidavit that says I was driving the car, the police pulled me over, and the police report says I consented to searching the entire car where the gun was found, but I never did it. I absolutely didn't do it. If I'm the judge sitting in a busy district court or BMC, or not busy, can I read that and say, I believe the defendant. Motion allowed, defendant. Gun suppressed. Do you think the Commonwealth would appeal that and come up to us and say, panel members, the judge can't do that? Would you?
Well, the judge can do that, yes, Your Honor, and I would note that once the defendant has met his burden, it shifts to the Commonwealth, and the Commonwealth gets to present evidence to an evidentiary hearing, put on witnesses to rebut what was in the affidavit. But this is a different scenario.
So what else, when you think about a house that's subject of a search warrant, probably other co-defendants are going to be self-serving. I don't think the neighbors will go to court and testify that they didn't hear the police officer knocking. To open the door to an evidentiary hearing, what else would have to be in that affidavit to entitle the defendant to an evidentiary hearing claiming constitutional violations? What more could he have put in there?
So I know in the Brisson case, which I cite, and I know counsel discussed, it was a case where I believe witnesses from the house testified at the hearing for a motion. So if there was someone else in the house, different affidavits, again, if they were willing to participate. However, I think it's important to show that the evidence has to be, the affidavit has to be in reliable form, and that's from Santiago.
But what you need, according to the rules, is, I'm the prosecutor. I need to know the scope of this motion, and I need to know what the issues are so I can call my witnesses and make my argument. The judge needs to know, what are they claiming here? What constitutional violation are they claiming? That's what the rule says, right? Just so that we're clear to get to a hearing.
Yes.
Did you have notice that the issue was no knock?
Yes, I think
Do you know
that,
what witnesses to call to claim that, in fact, there was a knock?
yes, Your Honor, I think the Commonwealth was on proper notice. I don't think that's the issue in this case. I think the issue is that the motion judge within her discretion, discredited the defendant's affidavit as self-serving based on the fact that he had filed multiple affidavits in the past, and his claim was, the evolution of his claims over time have been changing over a year period. So that's the important evaluation here, is that the judge is required in situations like this to find cause to give the defendant be entitled to a hearing. And in this case, she did not find cause, found self-serving affidavit, and then...
If we were to follow your logic in a non-search warrant search where you carry the burden, then I could look and say, I don't ever believe Officer X when he says anything. Motion to suppress allowed. I'm not even going to hear him. Right? That's the logic, is that the judge has a discretion because of the burden that because things were said before that weren't true, I can think it's not true. So I can then be on a warrantless search as a judge and go, that Officer X has lied before. I don't think he did this or that. Motion allowed with no hearing. That's what you want.
Well, I think it's taking out that this isn't the first motion that was filed.
Not the first time a police officer lied, is what the judge thinks.
So I guess I'd be confused if the defense attorney, if the officer had lied in the previous motion and if it was allowed or denied. I guess I'm just not.
The judge is making a credibility determination on whether the person's telling the truth. How come I can do it for the defendant, but I can't do it for the Commonwealth?
Well, I think just to put it
Or
back,
can I not do it? Can I not do it?
the judge is required to make a determination if the defendant is entitled to a hearing in cases like this, where this is multiple motions filed. And when she did that, after being presented with evidence that was relevant during argument, I know that's not in our transcript because we don't have one, was told that the defendant's affidavit has been discredited. And that same line, the officers failed to provide me with the search warrant, is still contained in the third motion to suppress affidavit, which was in front of the judge, completely relevant to the hearing. And to go back to Rubin's question regarding how the judge observed the defendant, I would just note to the cases like Commonwealth v. Houghton, it's Appeals Court case 39, Mass Appeals Court 94, where the demeanor of a witness in a courtroom has been considered even if the witness does not take the stand. Also,
There's no witness in this case, is there?
Because the defendant didn't testify, he's there. But there's also case law, Your Honor, there is no witness, correct.
Okay.
But also to point out that there is case law that states that a prosecutor may comment on the defendant's demeanor during closing arguments, even if he didn't testify, and the jury is allowed to consider the credibility, make credibility determinations of the defendant when he doesn't testify. So I would just note that the judge does have some discretion.
The defendant's demeanor while sitting at defense table?
Yes,
Yeah.
Your Honor. It's if I could just have a moment. Yes, it's Commonwealth v. Smith, 387 Mass 900. We have long held that juries entitled to observe the demeanor of the defendant during the trial. And that was when the prosecutor again commented in closing regarding his demeanor.
So I have one other question, I think, and we may not need to reach this. What evidence is there in the record of a knock and announce?
So, again, we don't have a transcript of anything.
There was no evidence taken anyway, right?
No, Your Honor, the officers, this was not based on the search warrant, the affidavit, the application for search warrant, officers did not apply for a no-knock warrant.
I understand that.
And the police report was read to the judge, understanding there was no evidentiary hearing. And in the police report, it says the prosecutor said line by line to the judge prior to the decision, officers knocked and announced their presence and made peaceful.
Don't you have to put some evidence in?
Well, again, it's skipping the step of determining if the defendant's
Well,
entitled
there was
to
a
a
search,
hearing.
right? For sure.
There is a search.
And so it has to be justified by the Commonwealth. The burden has shifted to you automatically under the Fourth Amendment. You have the burden to show that it was lawful.
But this was, again, probable cause was already determined, and this was a valid search warrant that was already litigated
Probable
a year.
cause for the search warrant.
So you're saying execution of
But
the
it's
search
the
warrant?
execution of the warrant we're talking about here.
Yes, Your Honor.
Don't you have to put something in?
That's only if the burden then shifts to the Commonwealth.
the burden shifts by what?
If
That
the
is, isn't the burden on the Commonwealth to justify its search always?
Only if the defendant meets his burden under Rule 13 to be entitled to a hearing. And since he did not meet his burden here, the Commonwealth did not have to present any evidence in this case.
I'm sitting at home. Police break down my front door. They come in. They rifle through my antique desk where they find the stolen gold coins. And I'm charged with possession of the stolen gold coins. I'm shocked. They've just broken down my door. My attorney says, well, we will certainly file a motion to suppress. And I sign an affidavit, and the affidavit says, they broke down my door. There was no knocking or announcing. I wasn't shown a warrant, and this should be suppressed. Your position is the judge can look at that piece of paper, in my case and every case, and say, I don't find that credible, and there is no hearing on the motion to suppress.
I think it's within the judge's discretion to determine credibility. However,
So the answer is yes or no. You're saying yes, the judge may look at those words on a sheet of paper and say, I find them not credible, and simply not hold a hearing on the motion to suppress.
I think that there are times when that can happen, like in this case where there was multiple motions filed and Rule 13 requires the judge. If this was the first motion to
I'm
suppress.
asking you if the judge can look at the words on the page. I'm not asking you if it's a multiple one and they might have some discretion not to hear. I don't know how that works, because later on inadmissible evidence is going to be offered at trial. There will be an objection and it should probably be not admitted, right? It gets a little complicated what you're supposed to do, but whatever. The judge looks at my affidavit and says, not credible.
Well, so, Your Honor, I believe that the motion judge has the discretion to discredit
yes.
affidavits.
Your answer is
Yes.
yes.
But is that
Okay.
fall into an abuse of discretion if that's the first time it was raised? That's a whole appellate issue.
I don't see how when I raise it. All right, so my lawyer also brought another, he brought a motion about the, whatever, opening the drawer, and now I say, no, you should have filed a motion about the knocking down the door and, and not doing this. And he brings a second one. And the judge doesn't say, I'm not hearing that. The judge says, I find this affidavit not credible.
And yes, Your Honor, that is appropriate based on the rule that the motion judge has to find cause to unwaive these.
Okay, so a judge
claims.
never has to hold a hearing on a motion to suppress. He or she can always simply read the affidavit submitted and say, I find it not credible, and the game is over.
So, Your Honor, I don't think it's as absolute as that. I wouldn't
You
say
haven't told me,
yes.
what else am I supposed to put in? No one heard it. I live in a single-family house, and I'm the only witness. So I write down and sign under pains and penalties of perjury.
And-
They knocked down my door.
And I think that you would be entitled to a hearing.
Because
on
I'm
the-
a judge and he's a defendant, or why? Like,
because
why
it was
is
the
mine
first-
any
It was
different?
the first claim you were filing, and in this case, Your Honor, even counsel stated he knew about the claim of knock and announce prior to not raising it, not until a year
That's
after.
fine if the judge had said it was waived, but that's not what happened.
No, Your Honor. And again, as I stated quickly, that it can be affirmed on alternative grounds based if the record supports it, but the judge does have the ability to determine, especially when it was explicitly said to her prior to the hearing, that the defendant, that the search warrant was inside the home.
So what I'm hearing your answer to Justice Rubin's question is that since it wasn't his first motion to suppress, that's the reason why the judge could say it's not credible.
Yes, because in this case,
So in Justice Rubin's scenario, he's the only person in his home. It's kind of like a gentleman in Moscow, I think, here with looking for the gold coins. Is that what's going on? but he says he's the person inside the house. He says this is what happened. And, there's a couple of other motions that go along at the same time. The second or the third one that he files that affidavit not believed because it's the second or third one, but the first one could be believed. That's what I'm hearing you say.
Yes, Your Honor. I mean,
Okay.
because they're not deemed waived. But now, and again, I understand that that's not necessarily the grounds that the judge found, but she did have to do a determination. And I think, again, why the transcript is so crucial in this case is to show that she was presented with how the defendant's second affidavit was found to be not credible.
I'm trying to figure out what happens later at trial. So now at trial, you go and you try to introduce the gold coins. And my lawyer, being tip-top, stands up and she says, "I object, Your Honor, these were seized in violation of the Fourth Amendment." What does the judge do? The judge says, "I'm sorry, that claim I've already ruled on, it was waived." Then we have an appeal. The appeal gets here, and what do? We have to judge whether there was a substantial risk of a miscarriage of justice, or he has to bring a new trial motion to create a record. I mean, presumably illegally seized evidence at the end of the day can't be used against someone, right?
So, Your Honor, I think that this is just, it's obviously outside what we're talking about here.
Sure, I'm just trying to figure out what happens if you don't hold a
But
hearing.
what happens here is that, like in this case, the defendant hadn't met his burden. He already was entitled to a motion to suppress. He did have that hearing. It was denied. Probable cause was found. His affidavit was found to be self-serving in this case. At trial, while the officer can be obviously cross-examined, did you knock and announce your presence? But again, there's no, this is different because there's no evidence that was, I understand that if you violate knock and announce, that's like the exclusionary rule, it takes out the evidence. I understand that point. But again, this is so off what we're talking about here. I would,
Well, I don't know, it's going to go to trial, so it could come up, right? I mean, this case hasn't gone to trial yet.
Yes, it has not gone to trial yet. But again, there's Rule 13 is there for a reason. I would just also cite to Commonwealth v. De Los Santos. It was a case that came out last year. I can give you the site, which is 492 Mass 242, that reinforced how important Rule 13 is, how it is the defendant's burden for Rule 13. It also did overturn Mundy, which again was a premise in defendant's
We're familiar
brief.
with it, yeah. Okay, well, we've taken you, thank you for answering all of our questions and all of our hypotheticals. We appreciate it. If we don't do it for sport, we do it because it's helpful to us to understand the issues. So we thank you both for answering all of our questions.
Thank you.
Thank you.
All right, the next case is Commonwealth versus Mark Love, 2022-1157. Good morning.
Good morning, and may it please the court. William Driscoll for Mark Love. In this case, the judge's abuse of discretion occurred by accepting the Commonwealth's invitation to apply the first-step Jackson factors to the third-step Batson-Soares inquiry. In doing so, the judge did not make sufficient facts to uphold the ruling, and therefore Mr. Love was denied a juror on his panel that he desired. That panel, the juror that was excluded was a black Jamaican woman. Mr. Love and the victim were both black, and that was the reason to get into the inquiry and pass the first step to start with. It was not until the judge made it clear to the Commonwealth that it appeared that the challenge was actually a pretext based on her background, having worked 4 years as a housekeeper at the Pine Street Inn, that she would be favorable to homeless individuals. Now, in this case, both the defendant and the victim were both homeless individuals. At that point, hearing that the peremptory challenge was most likely to be denied, the Commonwealth went into a rather long dissertation of how they're not prejudiced, that This is a good faith argument, and Judge, you have to look at the 5 factors in Jackson in order to decide whether I have an adequate and genuine reason for my peremptory challenge. And the judge listened. And actually, the Commonwealth only touched on the first 2. The judge accepted the first factor in Jackson, and those were his findings for allowing the peremptory challenge. That was entirely wrong. The defendant had already executed or exercised one peremptory challenge against a black individual, a man who had a friend and a family member stabbed to death or involved in a stabbing, which was the exact same scenario as this case that Mr. Love was facing. The Commonwealth did not object to that peremptory challenge, and that juror was excused. That was held against Mr. Love.
I don't think that's right at all. I don't think it was held against him the way you're saying.
Okay.
I think the judge was saying, and that person was not, there was no attempt to strike that person by the Commonwealth.
Correct.
So it's just another data point. He wasn't saying because you struck someone African American, he can strike someone African American, I don't think. It read more like he was just saying, we've had 2 African American jurors come up that the Commonwealth hasn't tried to strike, and one of them sitting in the jury table, and one of them you struck. And I don't understand why that's problematic.
I read it from the transcript at page 133 and 134, where the judge outlines his 3 reasons for finding an adequate and genuine peremptory strike. No peremptory strikes have been exercised by the Commonwealth against a black person until now. His second point, or the judge's second point, was, just for the record, I want to point out the one peremptory challenge I do remember being exercised against a black person was exercised by you, the defendant. That's where I'm coming up with that.
I mean, I see what you're saying, but it seems a little bit like
It's only
it's
their
hard to
first-
tell whether the judge is elucidating the prior sentence, which is, so where are these other black jurors, right? There's only one person saying, I mean, I hear what you're saying.
And that comes directly from the point that was argued, the Jackson point, which is supposed to be used for the first prong, not the third. The number and percentage of group members excluded from the jury service due to the exercise of a peremptory challenge. That was the first Jackson factor. And this is how the judge ruled, based on the Jackson factors. And that was an error of law, because Jackson does not apply to, those 5 factors do not apply to the third prong, whether there is a adequate and genuine purpose.
So if we're to entertain your argument that the comment by the judge with regards to defense counsel's challenging of an African-American juror somehow got into the mix improperly, don't we still look to see if the stated reasons by the judge are sufficient for both the prong of genuineness and adequacy? So even if the judge shouldn't have said that, shouldn't have factored that in, isn't there sufficient findings by the judge? I mean, it's really about the adequacy, isn't it?
It is, and the judge's third point is, we already have a black juror on the panel. And so those in themselves are insufficient to hold the adequate and genuine.
So the adequacy of this particular juror, when the judge, after some back and forth, says, well, in fact, I had initial concerns about the juror's ability to understand English, right? Or to communicate. Isn't that enough?
I say no, because on the record as a whole, when the juror said, oh, yes, I'm a Jamaican, we speak English, and the judge says, oh, you're doing very well. And before the Commonwealth starts with the Jackson factors, the judge says her answers were very thoughtful, very articulate. She didn't understand the question you posed to her, but it didn't surprise me at all. That's why I rephrased it, and she answered it perfectly.
So I understand what your point is. I guess my counterpoint is, in trials, oftentimes judges have a tendency, myself included, right, to think about themselves. And, oh, I didn't have any difficult understanding him or her. But then the judge seemed to put the right cap on an analysis. My job is to go through these factors and determine whether it's genuine and adequate, prosecutor, for what you have cited. And I do find the genuineness of your reason. And then on adequacy, I have to admit, I had that initial concern too. And so regardless of the judge's own thinking of, seems like a good juror to me, when she analyzed it under the factors that she's required to, it seems to me as if she had a stated basis for her adequacy of the prosecutor's reasons for the peremptory challenge. Tell me where you disagree.
In the sentence after what I just quoted,
Yep.
I don't sense she had any trouble with English. I am concerned that her background here at the homeless shelter is part of the reason why you're using this challenge. And I just think to exclude her raises an appellate issue. The judge had it in her mind. This is a problem here. This does not seem adequate and genuine. If it wasn't for the Jackson factors coming into play, the judge wouldn't have held her hat on the fact that the Commonwealth was saying, I'm not prejudiced, I don't care if they're black, white, yellow, I'll take anyone on my jury, I'm for fairness, and let's look at the Jackson factors, which, by the way, don't apply here, but I didn't mention that. They don't apply at all in this situation, and to apply them is legal error. So where do we go from there? Do we go from the...
So I'm just trying to, the judge at the end of the day, despite having found apparently no pattern of one, whatever, nonetheless leaps to, can this be justified on a race-neutral basis that's adequate and genuine? So that's what we have to look at, right?
Correct.
Okay. So to me, the question here is, and maybe I'm missing something, and this must happen sometimes, and I don't know, maybe you'll tell me there's a case about it. A judge says, let's make it this case, but let's make it like crystally clear, so I'm going to change it around a little bit. The judge listens to the person being voir dired, at first thinks, oh wow, she has a heavy accent, but then realizes, no, I can quite well follow her. She's asked a question, she has to have it repeated, she doesn't seem to understand it, and it's asked a different way. But the judge thinks, well, it wasn't phrased that well. So I think that's what the problem was. And I find that she is capable and competent and stands indifferent, and I would seat her. And now a party comes up and says, I know you found that she could communicate well, but I don't think she can. You asked about her accent at the beginning. I had the same problem. You said you could then understand her. For me, it was a little mixed. She had to have that question repeated to her. I understand you say it was a poorly phrased question. But in my view, no one else has had any trouble with it. I've been saying it the same way. And to me, this just suggests maybe when they're having a complex legal discussion in the deliberation room that she may have a little trouble. I'm exercising my peremptory. If it was clean like that, would that be a permissible race-neutral reason, assuming the judge found it genuine? Is it adequate, is my question.
The judge would then have to ask, is this the association, the group of people at issue here, Jamaican? We have a Jamaican woman. She speaks Jamaican. They speak English. The Commonwealth even said so. But she does have an accent. Do we exclude all Jamaicans?
Well, I
who
don't
have
know
an
the
accent?
answer. I don't know the answer to that. In this case, the point wasn't we're going to exclude all Jamaicans. It was about her specifically. I would think, although I understand that it may be, could be used as a proxy for ethnicity, that someone who is not a native English speaker, who spoke whatever language, maybe she is a native English speaker, but, you know, accented Jamaican English, if someone had a heavy accent, I can imagine someone saying, look, I just think this is going to be a problem. And so I guess I'm asking you, is that a race-neutral reason or it isn't?
Well, apparently the Commonwealth's the only one that felt that it was such a heavy accent.
All right, you know what? You haven't answered the question that Justice Rubin is asking you, and Justice Walsh asked you the same question earlier, which is whether or not the judge had some issues beforehand. And Justice Rubin has put the facts in a manner in which we can put aside some of the chaff, if you will, right?
Yes.
And we still haven't heard you say whether or not that's race neutral or not. If we assume it's genuine, if the prosecutor is genuine, all right?
Yes.
Okay, and says, this person, I don't think can understand the language well enough to deliberate. Judge, I know that you understood the juror. I don't think so. Is that adequate?
That would be adequate. However, in this case, it was not adequate because the judge found that this was a pretext, because you don't want this woman with a history of working at a homeless shelter.
Did she
That's
find
the
that,
real
or did she
reason.
just probe the prosecutor about that issue?
And-
I didn't see any finding about that.
Oh, on page 129.
Well,
Sorry, that's race neutral. It's not a pretext. Working at a homeless shelter is not a racial characteristic.
No, but using that as a pretext to exclude a black Jamaican woman would be.
I thought you said, the judge said the real reason was the shelter.
The judge stated 3 reasons at the very end. They were all based on the first factor in Jackson, which is not a permissible way of deciding the third step.
I see. Okay.
And those 3 all have to do with race. We have a black on a juror. The Commonwealth has not had a previous black peremptory challenge, and the defense excused one black person already, albeit for a good reason. So if the transcript ends before the Jackson factors come into play and the talk of how I am never prejudiced, 120 would rule, peremptory challenge would be disallowed. I see my time is up. If there are any questions?
I don't have any questions. No, thank you very much.
Thank you, Your Honors.
Morning.
Good morning. May it please the court. Erin Knight on behalf of the Commonwealth asking this court to affirm the defendant's conviction. If I may start with Justice Rubin's question, I do believe that is a genuine and adequate reason, and in fact it is race neutral. Anyone can have a thick accent, whether or not you're white, black, or any
What
other
if
race.
it's a Spanish accent?
A Spanish accent could also be a white person, a black person, a Hispanic person.
Well, it would likely be a Hispanic person, right? It
It
wouldn't be 100%.
could, but it could also be
Yes,
a
I
black
agree,
person.
but it's high enough correlation. We get to, that's an issue, right?
The correlation, I'm sorry.
Yeah, a correlation with race
Yes.
might well be a proxy for race.
If you're talking about the accent specifically,
Yes.
Sure, it could, but in this case it wasn't, and I can tell you that because looking back at the pages 107 through 133, where this lengthy questioning took place of both the juror, the prosecutor, and the defense attorney, what was clear is the prosecutor was trying to make clear to the judge that the communication was the issue, not necessarily just the accent, but she also asked the judge to repeat a question. She also asked the prosecutor to repeat a question. Whether or not the question from the prosecutor the judge thought to be compound or a bit difficult, that could also relate to her ability to communicate and answer questions or answer her thoughts in the jury room. I would also point out that Your Honors are also correct that her association with the homeless community, though she stated that she didn't have specific interactions with them, she did state on in the transcript that she did, in fact, it was very touching to her heart. And
Did the Commonwealth rely at all below on the homeless shelter?
He did try to proffer that. The judge kind of shut him down and wanted to talk more about the communication issue. So he did proffer that. It is there. He moved on to the communication issue because of the questioning of the judge herself. So both of those reasons are, in
Although,
fact.
for clarity, when he did try to proffer it, he didn't directly, he was wrong in the sense that he proffered that she was an employee of this homeless shelter, and it was that her passion was taking care of people, but and it was in a cleaning capacity at the homeless shelter. And so then it just went to the next, but it wasn't a straight-on.
Well, yes, Your Honor, if you're looking at that transcript excerpt, but if you look at the excerpt on page 110, according to the prosecutor's question, it was about her time with the homeless community, and she stated, it's very touching to me at this time because I have firsthand experience working in a homeless environment. So that is actually a different kind of, different situation in which the transcript shows that race-neutral reason. I would also point out, if I may go back and kind of break down the Jackson factor analysis a little bit, it is important that this court keep in mind that the Jackson case came out just a few months before this case, and that at the beginning of the peremptory challenge, the Commonwealth challenge, the judge said dismissed. Right, and then she went back because the defense attorney was like, wait a minute, I want to make a Batson challenge. So I think there was a little bit of back and forth about whether or not there had been a showing in the first instance for that first prong. And Your Honor's question, Justice Walsh, about would it matter if the Jackson factors, it doesn't. Because here she clearly went back and knew the standard was the adequate and genuine. And if you look under Maldonado, the adequate and genuine analysis is an explanation is adequate if it is clear and reasonably specific, personal to the juror, and not based on the juror's group affiliation or related to the particular case being tried. That's adequate. Adequate here, it was related to that specific juror, her ability to understand and communicate. Then, if you move on to the genuineness, it's whether or not the explanation is genuine if it is in fact the reason for the exercise of the challenge. And I would say he gave more than enough information as to why her ability to communicate would be at issue in a murder case for a jury.
We have to defer to genuineness, it seems to me, because the question is the prosecutor lying? And we're not,
A credibility
right?
determination.
We're not there. The judge is
Certainly.
listening to all of this. But adequacy has some legal issue in it. What's an adequate reason? What's race neutral, and so on.
Sure.
So let me ask you this. A judge is going through voir dire. Every time a person with an accent comes up, the judge says, I don't think that'll interfere with the communication in the jury room. And every single time, the prosecutor says, I move to strike that person. I do think it will interfere. Okay, not okay?
I would say that not every time you would be able to do that. And the reason that I say that this case he is able to do that here and it is proper is because it wasn't improper motive based on race. It was between the two of them, the prosecutor and the juror, there was communication issues, there was repeating of the question. Between the judge and her first instructions and the juror, there was asking to repeat a question so she could understand, and the judge did ask if English was her first language. I do think that in this case, it is separate and apart from just an accent.
Do you have a case where a judge made a finding of fact, and the peremptory was allowed because the party using the peremptory disagreed with that factual conclusion?
So you're asking if the Commonwealth disagreed with the judge's
Because
factual
they go
conclusion
through
or
this a lot. Even the judge says, like, well, I found it was okay.
Well, so
But people are entitled to different opinions based on this.
Absolutely, Your Honor.
But are there cases that say that? The judge has said you can understand. The person, either defense or prosecutor, is using a peremptory on the basis that they disagree with the judge's conclusion. Do we have cases like that?
Off the top of my head, I do not personally have one at this moment. I'm happy to research and do a 16L,
No,
but what I
that's
would
fine.
say, Your Honor, is going back to the standard, it's not whether or not the judge agrees with the Commonwealth's proffer. And I would note, she notes that multiple times, that it's not, the standard isn't whether or not she agrees, it's whether or not the explanation is adequate and genuine. And so the trial judge makes that independent evaluation specifically to determine whether or not his reasoning is bona fide or pretext. And here, she does go through the Jackson factors in determining whether or not the challenge is correct, and then he gives a proffer, which is step 2, and she does find that it's adequate and genuine. And there are 3 separate times in the transcript, pages 126 through 127, 131 and 132, these are all transcript 2, excuse me, all transcript 2, that she quotes that exact adequate and genuine language. So the trial judge here was in fact apprised and knowledgeable of the standard that she had to evaluate, and she did so. If this court has no further questions, I would rest on my brief. I do want to just state that I forgot at the beginning to let you know that this is ADA Dave Bradley, the trial ADA with me at table, and the victim's family is on the live stream today.
Right.
Thank you very much.
The questions? No. Thank you very much.
Thank
Thank
you.
you both. All right. We'll go to the third case that we have on for today, and I want to remind everybody that this case is impounded. It's a or partially impounded. Commonwealth versus a Juvenile, 2023-1121. So I'm going to correct myself. I initially said impounded, then partially impounded. I believe it is entirely impounded, so let's be very careful.
That is
Okay,
correct,
thank you.
Good morning. May it please the court. My name is Taylor Henley, and I represent the appellant Juvenile. Social media can be many things. It can be a space to share life updates or connect with old friends. It can also be a tool for misinformation and deception. But for all its uses, good and bad, social media is not reality, and it cannot be the basis of an in-court identification by a complaining witness when no out-of-court procedure was ever conducted.
Ever? Go ahead.
I've never met Taylor Swift. But if I saw her somewhere, I think I could identify her. How? Through all the pictures on social media. So how is that any different? You can. The cases that you cite are about the unknown person and the person with the white shirt and blue pants and green sneakers running down the road, right? And that's the same person who is running down the street. It's not an identification, right? The social media, though, I know who Taylor Swift is. I could point her out in a crowd right now, having never met her, because I'm familiar with what she looks at, because she's on the news all the time. How is this any? I know it's different, but if that works, why doesn't this one work?
I think there are 2 reasons, Your Honor. First, in your example, Taylor Swift is a public figure. She's not only been on social media, she's also been on the news, as you mentioned, on television.
That's about how do I really know her, right? I mean, that's kind of weight. But can I
Certainly.
use social media to identify somebody?
Right, so I think that there are sort of 2 issues in your hypothetical. The first is comparing someone who has been a public figure for quite some time versus a social media post. But then I think looking at the facts, particularly here, the person who the complaining witness says he saw on social media is not a public figure. It is not someone who has been on the news. It's not someone who has been in the public eye for years and years. It's someone that the complaining witness says he saw 4 times on social media on a highlight on Instagram.
Doesn't that go to weight when you look at the candy red hair and things like that, that would be memorable versus not allowing it in? I mean, isn't that I'm seeing somebody on social media enough to be able to recognize them?
No, I don't believe so, Your Honor, and I think that the reason for that are the reasons that are outlined in the Creighton case. And so the Creighton case considers things like weight and considers that a jury could perhaps evaluate some of these identification pieces as well, and says that that is not enough because jurors are not well equipped to evaluate an identification, and Creighton puts in place the good cause reason, the familiarity standard, precisely to protect against that. To get back to here, to go back to Your Honor's original hypothetical, I mentioned that the attacker was seen in the friend's highlights 4 times. We don't know how many people were in those photos. We don't know if those were photos. We don't know if they were videos. We don't know if those highlights were close up or far away, blurry or clear, edited or not. We don't know what people were wearing in those photos, if they were wearing hats or sunglasses or scarves. The only thing we know is the one distinguishing feature here that the complaining witness says is the candy red hair, as Your Honor mentioned.
Well, there's a little bit more because, of course, there was the fact that there was a relationship between the person identified, the juvenile, and a very close friend of the victim, right?
Yes, there was
So there was a little bit more. And there's also, of course, you can't look at it just on the social media posts because there was also an opportunity to view and identify the person at the time of the attack.
Yes. However, I think to go at, I think those two things separately here. So first, looking at
Why don't they reinforce one another? Why do we look at them separately?
I think primarily because of the Creighton case outlines the 2 reasons for that constitute good cause. The first is familiarity. Familiarity being the people know each other prior to the incident, and the second is the extensive and intensive observation during the alleged incident. So to go first to the familiarity piece that Your Honor has referenced, I don't think that the fact that the complaining witness knew the friend and saw on the friend's highlights the person that the friend says is the friend's boyfriend is really particularly dispositive here, because we don't have any of those photos, as I mentioned, and we don't have...
No, but if anything, it implies that there was, that the victim actually looked at the photos. I mean, because there was a relationship and he was looking at what his friend's boyfriend looked like, just, right? And isn't that what the import is of that relationship, that there was a reason why the victim would have focused, be it 10 seconds or 3 minutes on a particular photo?
Sort of, Your Honor, but I think perhaps here it might be helpful to clarify Instagram and sort of how that works. I don't know if Your Honor is familiar, but essentially, I apologize, I assumed not. But I think it might be helpful to explain a little bit here how Instagram
We
works.
do all have children and grandchildren, so don't think that,
I can tell you from both personal experience and from this case, I am a little more familiar with Instagram. And the way that Instagram works is that people have their own pages. They post whatever they want on their pages. And so,
And they explain this at trial, though, also, right? And they also explain how those pictures were up and how long they stayed and things like that.
yes. So it's not as if the complaining witness's friend showed a picture to the complaining witness and said, "This is my boyfriend, look." The testimony is instead that while the complaining witness was looking on his friend's page, he saw pictures of someone he believed to be his friend's boyfriend. I think that's a little bit different than showing a picture saying, "Hey, look, this is this person, this is my boyfriend." But I do also want to get to the other thing that Your Honor mentioned, which is the extensive and intensive opportunity to observe, which is the other factor to constitute good cause, and that was not met here either. The complaining witness testified that his alleged assailant was wearing a ski mask, that the only thing that he noticed was candy red hair.
Well, he took the mask.
Yes.
Time he took the mask down.
I apologize. And he took the mask down to say
Whatever.
some words and then ran away. And the cases that talk about extensive viewing talk
How
about...
can you ignore the fact that the victim immediately knew who it was and said so immediately, identified the person right away? To the police, I mean, he didn't think, I think it's so-and-so, or it could be so-and-so. Now that I think about so-and-so, he immediately identified the person. Isn't that significant?
I don't believe so, Your Honor, and the reason is because all of the volume of literature on identification shows that a victim's or a person's confidence in their identification does not correlate to...
No, it's not confidence. Doesn't it really have to do with familiarity? Doesn't it really have to do with the fact that he was able to make that identification at that point? Doesn't it reinforce that?
I don't believe so because they never met in person. And so you're still having an identification based on something that you saw on social media. And someone on social media, you could have a post with filters are very easy, they're prolific.
But there was no evidence of that. There was no evidence that there was any kind of misconstruing or filtering or anything like that in this case.
There was no evidence of anything because we don't have the photos. The Commonwealth could have provided the photos, and then we wouldn't be here arguing about what the photos showed. They did not. The alleged victim did not provide those. The Commonwealth did not provide those. And so instead, we're left with an unknown. And
Are we allowed to use our common knowledge about Instagram?
I would say yes, but I don't know that it's needed here because, as Justice Vuono pointed out,
Well, I
there was
think
some-
it probably helps you, doesn't it?
Certainly, I think it does help.
My understanding of Instagram, in fact, as I've seen it, and I don't know the terminology that this other juvenile, the victim, used, but there are these things where you can where across the top, there are little bars for each clip or picture or whatever, and it sort of moves among them. If you had just one, I guess it would only be up. They maybe aren't up for very long. I guess it depends, although we have nothing in the record about this, depends how many of the little bars there are. If you have, I don't know what the max is. I've never posted to Instagram. I know a very limited amount about it. But my sense is it's not like you click on it and the picture just stays there and then you look and stare at it for some substantial period of time. It's up and then it goes away and then there's another one or whatever. Is that your understanding, or are we supposed to know that? Or, I mean, there is some talk about what it is in this thing. It's not the disappearing text or whatever.
Yes, and so I think that a reading of the record, albeit helped by my familiarity with Instagram, I think does show that it was a highlight, so it's not a permanent picture. It does disappear, but you can keep it up for a certain period of time until you replace it. So it's not, I think, a post that stays up forever. It's a post that stays in a highlight reel at the top of the Instagram. But I think the important thing here is that even if it was a post that stayed up forever, we don't even know how long the alleged victim looked at that photo. And again, we don't know anything about what that photo actually looked like. I do want to...
Areas where, of course, you could have cross-examined. There was a voir dire here at trial.
Yes.
So when you say we don't know, I mean, these are also issues that could have been developed by defense counsel.
Yes. However, I don't know that it was needed here because I think this point still stands that viewing someone's post 4 times is not sufficient to constitute the kind of familiarity that the SJC contemplated in Commonwealth versus Creighton. I think it's important to point out here that the example that the Commonwealth versus Creighton case used to constitute familiarity was a case of domestic violence. And the point is, for a case of domestic violence, the parties know each other quite well, right? To have the police go through a lineup or a photo array for 2 parties who've been in a relationship for however, who knows how long, is sort of a waste of everyone's time. And here...
But this is really in-court identification. So to avoid the danger that if there was the unknown assailant running down the street, but they happen to sit next to counsel table and be called defendant when they ask the defendant to rise, that there's not some sort of extra kind of heft when the witness says, and yes, I know that's the person who did it, that's the defendant right there, when all they can say is that the person who committed the assault was wearing red pants, white shirt, and green sneakers and was running that way. Different from when you know someone, right? And so, sure, the case law says domestic violence, but the basis is Creighton doesn't have that same heft when you actually know the person who did the crime, right? This is not like, oh, all I can tell you is that it was a person with this type of hair running down the street at a fast rate of speed, never seen him before. But because he's sitting right there in the defendant's seat, what was happening is that the witness was saying, and that's the defendant, I can identify him right there. That was the harm. This doesn't seem to ring true here when you argue it's not enough, but the jury was fine to believe that argument, right? The jury could have taken that argument and said, yeah, it really might have been a misconstrued assailant because we don't know how long he saw the Instagram. He's just confused about who really done it, right? That's something for the jury to determine. Like, this just seems as he's familiar.
I would contest, Your Honor, Your Honor's assertion that the two parties knew each other at this point, because
One party knew, right? To identify the other. That's what we really focus on.
yes, so I would contest Your Honor's assertion that the complaining witness knew his assailant. The parties didn't go to school together. That was in testimony. The complaining witness did not even know the person's last name. The complaining witness said a first name that is very common, and then said an Instagram handle that was never tied to the defendant or the juvenile who was before the court. So at first, I think, to the extent that Creighton was trying to prevent sort of an unknown identification, as Your Honor pointed out, I think that's exactly what we had here. And the Commonwealth had quite some time to do an adequate identification and did not do so. I think the second point, though, Your Honor, about the jury is important here as well, because the point of Creighton, and I think it's played out here in this transcript, is that once the complaining witness or an eyewitness makes an identification, the defense has to shift. And so here, the defense became not about the identity of the assailant because the complaining witness made an identification. And the SJC in Commonwealth versus Creighton talks very significantly about the harms that does in front of a jury and how hard, if not impossible, it is to persuade a jury of a suggestive identification. And that's the reason why Creighton does not allow these sorts of identifications. I do see my time is almost expired. I did want to raise for Your Honor the mootness issue. If Your Honors have no questions on that issue or on anything else, I'm happy to rest on my briefs on that issue as well.
Okay. Just see if there's any more questions. No, just one. Thank you very much for your argument.
Thank you.
Good morning, Your Honors. If it may please the Court, Timothy Farrader, Assistant District Attorney from Middlesex on behalf of the Commonwealth. And I want to start out with one observation about the Creighton case and whether the SJC requires familiarity with the level of domestic violence. I'd point out, right after they gave that domestic violence example in the Creighton case, they then cite to Commonwealth versus Carr, a case where the witness knew the defendant, quote, from around the neighborhood prior to the murder, and Kong Duck Lee, where that witness knew Mr. Lee from meeting him a few times in a social setting. And then this court, and certainly all the cases I cite in my brief, hasn't required the level of familiarity of domestic violence. So I don't think that is what Creighton requires, and certainly hasn't been what this court has required.
So far as we're aware, the victim never met the perpetrator, except at the crime itself, if the perpetrator committed it, if the defendant committed it. So they never met.
Correct. In person, correct.
In person. How many times do you have to look at a photograph of someone before the Commonwealth is excused from doing an ordinary photo array and can just have the person point in the courtroom in front of the jury at someone and say, that's the person who committed the crime?
I don't think there's a bright line rule, nor should they. I think it should be based on
But
the
4 is enough.
You're correct. I don't think there should be
3?
I don't think there should be a bright line rule.
Okay, but I need to know where this line is,
I don't
right?
think
We
there
have
is
no case where any photos have ever been used before to say that someone knows someone, and I take Justice Walsh's example, Taylor Swift. I don't particularly, I guess maybe I shouldn't say this because there are so many Swifties out there. She's a fine artist, but I don't follow her with any closeness, put it that way. I have seen, I don't know, 1,000 photos of her, right?
Probably.
Okay.
We all have.
That's a little different than a friend of mine's boyfriend who I've seen 4 photos of on Instagram. And I'm just trying to figure out, now we have language, I think it's dictum probably, but in Fielding, the court says, the victim had such an extensive and intensive opportunity to observe the defendant, and so you don't have to do the photo array. We'll let you do the pointing in the courtroom.
So that was during the crime in that case. I think the Commonwealth really moved on prior familiarity in this case and not extensive opportunity during the crime. So the prior familiarity was the issue in this case, and I don't think there can be a bright line rule about number of photographs. I think that's for the...
Sometimes my colleagues show me pictures of their children,
Yep.
and I look at them, and I'm delighted to see that they're doing whatever it is they're doing, and I show pictures of my daughter to others.
And if you...
Can I identify those children from having seen, I'm sure it's more than 4 times.
And if you testify that you've seen them 4 times, you can give the chronology of his hair color, and then when something happens, you immediately identify them, I think you could identify them. If the testimony is different, that I don't really remember much about them, then no. So I think it's...
But the hair color can't be what you're relying on, right? Because if all you had was hair color, we would clearly kick this out, right? Someone with red hair did it, and this person had red hair. Someone who used to have red hair. That's not a good basis for identifying someone,
It
right?
evinces the prior familiarity. That he is able to give this chronology shows how, I guess, familiar he is with the juvenile from the
But
photograph.
it's from a photograph.
So it evinces the prior familiarity.
I mean, you're asking us to stretch this good cause thing quite a bit.
I don't believe so.
Is there a single case where photographs have been the basis of the prior familiarity?
but I don't think
So
there's
that's
any-
quite a bit.
I disagree, Your Honor. I think photographs can be very, I don't know, easy. I think you could recognize someone easily from a photograph. The photographs behind you are very clear. And if I saw, I don't know who that justice is, I think I could recognize him now based on that very clear photograph. So I don't think...
This one.
That one's a little
That
more
one, this one.
difficult. So I think it kind of depends on the fact finding. So I think that's why it's for the fact finder to make the determination. And I don't think there's any reason to draw any rule between photographs and in person, especially not on this record. I think that's
But we're looking for a good reason not to do a photo array. You could have done a photo array 4 minutes before going into the courtroom with this victim. You could have,
Yes.
right?
That would have been a year and a half after the crime, though.
It was exactly the same time that he identified
Correct.
the person in court, so.
Right, and I would point out, to give credit to the police here, when they did the investigation on scene, there also was a second identification by someone with,
That's not in the record though, right?
it's at RA 15, it's not on the voir dire record.
It's
but
not, it's
to
not
answer the
before, it
question-
wasn't before the jury.
No, but to answer the question, why didn't the police do a photo array at the moment?
Why didn't the prosecutor do a photo array so that,
Right.
I mean, I understand maybe why the police didn't.
Right. So, but the question isn't why or why didn't they do it, but the question is why if there was a good reason. And I think there was no abuse of discretion in this case, where the evidence was such that he was able to say how many times he viewed him, give this
But that's not
description
the
of-
point, right? That might be fodder for cross-examination.
Right,
But an in-court identification of the perpetrator is so damning
right.
that we don't want to let it in and then have a bunch of cross-examination, but maybe you're not sure, or maybe his hair was cut, or maybe we don't want to let it in at all unless it's okay to let it in.
Right, but what Creighton talks about, that being particularly true in stranger cases. In a case like this one, where the witness is not identifying the defendant based solely on his or her memory of witnessing the defendant at the time of the crime, there is a little risk of misidentification arising from the in-court show-up, despite its suggestiveness.
They've
That's
never
page
met
242
each
of Creighton.
other. I mean, I find this very close, at least.
But it doesn't require meeting, it requires prior familiarity, and I don't think there's any reason to draw a line between photographs and in person. I think that is proper subject for direct and cross-examination, and I think the motion judge as the fact finder can weigh that. And I think here the motion judge, as the fact finder, found that there was a sufficient prior familiarity in this case to allow the in-court identification. And I think a lot of this, a different justice below could come to a different conclusion, but I think the fact finder in this case gets discretion, and I don't think she abused her discretion in this case.
Is it a discretionary decision, or is a good reason a legal question?
It's I believe it's abuse of discretion because it's based on fact finding. And of course, the judge would be in the best position to weigh the credibility of the witness during the voir dire. So I do think her fact-finding is given discretion. Anyway, if there are no further questions about the Creighton issue, I will, is there?
No further.
I will touch on the jury instruction. I just want to point out that the juvenile, in his reply brief, phrases for the first time that this jury instruction could have gone to intent. I just want to point out the way the instruction was given to the judge below. It was not given as an intent instruction. It was, quote, "These differences are characteristics that you may consider as you listen to the evidence in this case." It was more about the evidence as a whole. This is different than mental impairment short of insanity or a intoxication instruction, which this is from the model instruction from the district court. The defendant's mental condition may be relevant to your deliberations on the issue of whether the defendant had the criminal intent that is required for the conviction of this offense. This really instruction just went to the whole case and not specifically into intent. I think this was raised for the first time in the reply brief and doesn't reflect the instruction as given. And if there are any other questions?
As given, or you mean as
requested.
As requested.
Sorry, as requested, Your Honor. And just on the mootness issue, I just raised that to point out that there is currently no rule or case that allows a quaff to be appealed, and I think a court should probably say one way or the other. I think there has been many exceptions found. I know for the immigration consequences, Justice Rubin, you found one in Argueta where the quaff counts towards federal sentencing guidelines, and I would direct this court to footnote 8 in Preston P, which lines, and I think my sister did a good job of pointing out the collateral consequences for a juvenile, particularly looking at Preston P, footnote 8 lines out all the collateral consequences. So I was just pointing that out because I don't think, the general rule is that a quaff can't be appealed, but I think a court, Magnus M created a loose end that needs to be decided one way or the other.
Can I just, I'm having a difficult time hearing, are you conceding that mootness isn't an issue? Is that what you're saying?
I think it is an issue because no court and no rule has said one way or the other, but I think my sister's points in her brief are well taken. So that's what it is that I'm making a point, just to point that out.
Can I ask a further question about the identification?
Sure.
Does it matter that his identification of the person he named at the scene may have been based on a lot more than visually seeing the person? That is, Ashley asked him to, I don't know if I'm supposed to even use.
Well, that's all right.
Okay, well, it's too late.
It's all right. She's not
His
directly
friend
involved.
asked him to walk with her or something, and he seemed to think that that was some kind of trap, maybe. There were people, I don't know if he knew about it, I don't remember all the details, sitting outside his school as if waiting for someone. And then, of course, the thing that this person, that the perpetrator says to him, which I'll paraphrase as, stop talking, it may be that, in fact, he had been talking and therefore knew about that person. We don't know anything about that, but it may have been that he certainly knew what was being referred to right then.
Yes, I think that's something the fact finder could weigh. It could be positive that, this was based on.
Well, but that's not good for a visual. That has nothing to do with the visual identification.
It could be negative. I think on cross-examination, a question could have been asked, did you assume it was Anthony because did you assume it was A because you had just spoken with your friend A, 2 different A's. So I think that it could have been subject to cross-examination that wasn't brought out in this case. But I think that would be, something the fact finder could consider, but I don't think that makes it an abuse of discretion in this case.
Interesting.
If there are any further questions, I'd be happy to take them. If not, I'd rest on my brief. Thank you.
Thank you both very much. All right, we're going to hear one more case before we take a short recess. The next case is also impounded in the matter of a juvenile, and it's 2023-0779.
Good morning. Thank you. If I may please the court, my name is Christine Hamilton-Caros. I represent the appellant child in this case. Before I begin, I'd like to set
I'm just going to ask you to bring the microphone a little bit closer to you, if
Sorry,
you
I'm
don't
a bit
mind.
short.
Me too.
Sorry.
No problem. There you
They're
go.
both exactly the right size.
We're the right size.
So before I begin, I'd like to set the framework for Section 35 commitments, and that is that involuntary commitment under Section 35 is to be used as a carefully circumscribed tool of last resort, and that's only when there's an imminent risk from a substance or alcohol use disorder, and that imminent risk is at imminence for causing serious harm, and in this case, it's a very substantial risk of serious bodily harm to the child. And there's no lesser alternative plausibly available to mitigate that imminence or that severity of harm.
Do you deal with these cases a lot?
The Section 35 cases?
Yes, particularly with a juvenile.
No.
Okay.
I apologize.
I'm just trying to figure out, I'm just surprised that it's all kind of hearsay and there's no, there's no medical record from the night before. There's no, you know what I mean? It's like, where's the, like, where's the hard documentary evidence that might be useful? And I was just surprised that that's not what was presented, but I haven't seen a juvenile Section 35 case before.
So there's no separate standard for juveniles and adults. The standard is the same. And because these hearings are held relatively quickly in a relatively short period of time, it's very difficult to get that sort of evidence in. And so the criteria is, the rules of evidence are a bit relaxed. The standard is clear and convincing instead of beyond a reasonable doubt. And hearsay is allowable, is admissible. However, if the judge is going to rely on that hearsay, the judge has to explicitly state the indicia that the judge relied on to determine that that hearsay was substantially reliable. That protects the due process right of the individual faced with a Section 35 commitment. The difference between a juvenile and an adult is only in the factual analysis, and that's because juveniles have issues with adolescent brain development, which throughout their adolescence continues to develop and affects decision-making, assessment of risk, willingness to take risk, and that is very important, and that is why I argued that the prior reports not being allowed, the juvenile not being allowed to view those prior reports.
What, were they physically present, but the juvenile wasn't allowed to see them, or they had been relied upon by the expert and they physically weren't even present in the courtroom?
I apologize, I didn't hear the beginning of the question.
In the courtroom, were they physically present? Like, were the reports there, but the juvenile was not permitted to see them? Or they weren't even there, and so therefore the juvenile couldn't see them?
There's no evidence either way where those reports actually were.
And what are they? Do we know what they are from looking at the expert's report? What?
Yes, they're two prior clinical, court clinic reports. And those reports, that expert relied on those reports not only as best practice to conduct these type of evaluations, but also to develop her strategy for interviewing all of the people she interviewed. So she used that information to create her template for what she was going to talk about in the interviews. And
she is a court employee?
She is a court clinician. There was no evidence about what level of court clinician, what experience she had. They didn't go through that.
And she's called as a witness by the mother?
No, court clinicians regularly testify in these cases. Once a Section 35 is filed, the court clinic assigns a person to do an evaluation.
Okay.
So,
But focusing on
like a
this
gown.
particular case,
Weird, though.
when we look at the transcript and the objection was raised, the clinician testified that she waffled a teeny bit, I agree, but she would try her best and that she would base her opinion not on the prior clinician's reports, which were used for background and information, but she would base her opinion that she was presenting to the court today from her interview with the defendant, her evaluation of him, the mother, etc., correct?
That is correct, Your Honor. However, the clinician looks at the facts of a case from the viewpoint of a clinician. The judge looks at the facts of a case from the point of view of a fact finder. And so the legal criteria is not necessarily the same as a clinician's criteria of substance use, disorder, or risk.
Ultimately, it's an opinion like any other opinion. So Section 35 requires, upon admittance into a court, an appointment of counsel and an evaluation by a clinician, which is a broad definition of what qualifies for clinician. But included in that, so when the court takes the testimony, and in this instance, it's really generated by the court, right? So in essence, there is no moving party like a typical, the court is calling whoever is there to testify. And the court relied upon the signed affidavit under pains and penalties of perjury by mom, relied upon to the extent that she credited a clinician's testimony, and relied upon the mom who testified, correct?
That is correct. However, the court is supposed to go through an assessment on the reliability of that hearsay, and she didn't do that. But even if she had...
In the case of minor M, what the court prohibited judges from doing in Section 35 is merely parroting the language that you, in fact, suffer from a substance use disorder and you require the highest level, et cetera, right? That was not enough for due process, and so too was reliance on hearsay. Due process requires some explanation. And when I read the judge's, not magic words, substantial reliability, because I think we'd be in the same boat as minor case, but when I read the judge's factual decision, and oral findings are fine, minor M said that, right? She cites all of the reasons. She doesn't use the magic word substantial reliability, but she cites the testimony.
So there are 3 points which I would say contradict and fly in the face of being able to find under any one of the elements needed, and it starts with those prior reports. With a juvenile, the court is supposed to evaluate how the adolescent brain development may affect the decision-making and ensure that it's not that is affecting the poor decisions and, in fact, a substance use disorder. And where the juvenile wasn't allowed to see those prior reports and review them, there was no way to prepare to poke holes or to show how the clinician was looking at only a snapshot in time rather than his progression, whether it was better or worse. There was no way to know what was in those reports except that the clinician did say there could be relevant information in there.
You would agree with me that 2 clinicians could find somebody at one particular point in time to be, and everyone agrees, to fit the criteria of Section 35. Fast forward 4 months later, the clinician evaluates that same person, juvenile or adult, and he or she may not meet the criteria, right? It's a snapshot of time. Right? So it's not, well, you were committed before, therefore you are committed again. It's today, with the information that I have, Judge, my opinion is that this person before me suffers from an alcohol use disorder or a substance use disorder.
Yes, and that is her role, but the judge's role is to look at how adolescent brain development is affecting that adolescent's decision-making at that time. And in order to do that, you have to look at a bit of history if it's available.
I'm sorry, you're confusing me. I feel like we're talking
sorry.
about 3 different issues, and I'd just like to keep them distinct. The first is the reports. They were not provided to the juvenile, although, and at the end of the day, we have the clinician saying she'll do her best not to rely on them, and maybe that's adequate and maybe it's not. If it's not adequate, and we think that this infected it, there's a due process question, right? That's question
Yes.
one. So I don't know what the answer is, but let's put that here. The second question is the reliance on hearsay. And the reliance on hearsay, we have this in the matter of a minor case, and it talks about exactly what a judge is supposed to do to find hearsay reliable. And maybe the judge did or didn't with respect to the mother's testimony. We have to look at what is said there. The judge certainly said nothing about the father's nested hearsay. I suppose there's some other nested hearsay in there as well. So that's question two. Was hearsay that was relied upon, was it procedurally correct? Now you're raising, and I'm not sure I saw this in your brief, this brain science thing.
Yes.
Is that in your brief?
It is in my brief, Judge. I would have to submit a 16L letter to, I don't want to cite the page incorrectly, inaccurately. It's from minor.
You don't have, we can look at the brief, but it's in there, this brain science question. And your point is that the judge was required to say something to draw a distinction between substance abuse disorder and mere immaturity through underdeveloped adolescent brain.
The judge needs to clarify that there's a nexus between a disorder and the risky behavior, and the behavior that's placing the minor at imminent risk.
Okay, now let me ask you then this, because those procedural things may require reversal. I don't know the answer to that. Now I want to look at the merits of the determination. It seems to me that if this juvenile overdosed the night before, then this is a substantively okay determination, leaving aside that maybe we don't have adequate, the hearsay shouldn't have been in there, and I see you looking at your clock, and that's okay, but if you need a little more
I apologize.
time, we'll give it to you, because I'm taking time with this question. I'm inclined to think that if this juvenile overdosed the night before, then maybe he's a serious risk to himself.
Judge, I would not agree that the court made the correct determination on the overdose. If you look at the evidence, the medical evidence was that the doctor and the EMTs...
The medical evidence, and I don't understand this, and I didn't litigate the case, and I'm not the mom who I guess is the legal guardian, is the mom?
Yes.
The parent. So she could have asked the hospital, and I guess they would have had to do it. I don't know what the rules are for consent for a 17-year-old or however old this juvenile was. They didn't do a drug screen.
Judge, the only reason he got to the ER was because of the Narcan.
I agree with that. But the doctor said, this is hearsay also, if we believe what the mother said, the doctor said if he had had an opioid overdose, and I don't know if this is true as a medical matter because I'm not a doctor, he would have shown symptoms of withdrawal when the Narcan was given.
Exactly, Judge.
Now, I don't know if that's true or not. I don't know what percentage of the time it's true. I would have thought, but this is total lay thing, that if you respond to Narcan, you must have had opioids in your system. But again, I don't know. And the doctor says this. But the doctor doesn't say, and I did a blood test, and he has no opioids in his system.
The doctor also didn't say he needs to be committed or we need to hold him. And the EMTs didn't even want to transport him. I would like to just point out that Mom's testimony is 6 pages. It's very sparse. The judge did not ask her any questions about that night. She didn't ask one question. There was no testimony from Mom or the stepfather who was in the courthouse about what actually happened that night. And Mom's testimony is that he'd gotten on the honor roll at school. He was living a normal life. There were no withdrawal symptoms.
How do we know? I know, and I assume it's in the record, but maybe I'm wrong. I seem to recall that someone tried a sternum rub to rouse him. It failed to work, and rather than waiting the 10 minutes maybe that the mother wanted, the stepfather immediately gave him Narcan and he responded. Am I wrong about there being evidence of that?
That was hearsay, which there were no determinations about the substantiality of that hearsay.
Okay, but that I've put the hearsay thing may be
Yes.
the end of the case, okay.
And it was the stepfather.
But if this hearsay was properly in, why doesn't that support the judge's finding I know the doctor said no withdrawal, but I think respond to Narcan. Look, again, I'm not an expert.
Because he didn't need the Narcan, he didn't need the sternum rub. Mom had been administering him Percocet anyway for the foot.
He didn't wake up from the sternum rub. Now, again, I'm not a doctor. I don't know anything about it. That everyone acts as though that's something you do with an overdosed person. I don't know anything about it.
I don't believe that's common knowledge, Judge. So the fact that the stepfather knew how to do this and didn't actually speak directly to the clinician, was there, but didn't speak to the clinician, was in the courthouse but didn't testify.
There is some hearsay evidence that he had been an opioid user at some point, right?
Yes, and I think because of the foot, that the mother was very on guard about any issues, but she did testify he wasn't a user of substances.
She
It was
doesn't know what
marijuana.
he does. How does she know?
Because she said she didn't see any signs, no nodding off, no issues with school. He was,
But on this occasion, they could not wake him.
that's what the stepfather said.
Well,
but-
again, we're also seeing the doctor said he didn't overdose. I mean, we're same thing. We're always looking towards people's opinions, and so if we're going to treat them all equally for a moment, for hypothetically for this, right?
Yes,
If we're
however,
going to accept the doctor, the ER, who I have no idea why he did not perform a blood test, but anyway, we accept the doctor's opinion, and then we have to also then accept the stepfather's opinion and the mother's opinion, right? So.
I would say that hearsay from a medical doctor and EMTs would be more substantially reliable than
And
the
what did the
hearsay from...
EMTs say?
The EMT said that he didn't overdose, that he didn't need to go to the hospital. He was fine. His
How
blood
did they
pressure-
assess that?
His blood pressure was fine, his pupils were, he didn't show any signs of overdosing.
Once you take Narcan, do you?
They're obligated to transport to the ER.
That's
Oh,
not
do
what
you
I'm
still
asking
show
you.
signs?
Would
Do
you
you-
show signs after taking Narcan, or would all of those signs dissipate as soon as the Narcan replaced the opioid at the receptors?
So what the evidence said was that he would start to exhibit symptoms of withdrawal, and he didn't. And his mom, the testimony was that he hadn't. The issue with the February incident the evidence is that was a one-time incident. After that, he was compliant with treatment.
The February incident is the foot?
Yes.
I thought that there were also drug screens or something from earlier.
So the evidence was that there was 2 drug screens. We don't know when they were. We don't know what they were, who took them, where they came from, in what environment they were taken in.
Do we know that they were for opioids?
We don't. The only thing that the record says is that there was 1 positive fentanyl screen. However.
A positive fentanyl screen?
Yes,
All right,
except
so
that
he had used, advertently or inadvertently, he had used fentanyl before.
there's no evidence under what circumstance that was, Judge. He had had an argument with his mom. He ran off, took refuge in the family trailer. He could have found something in the trailer after an argument.
And used it.
And used it.
All right,
Like
so-
some, kids just see something and, maybe this is going to make me feel better. She didn't do any evaluation about how his adolescent brain development affected his decision-making or whether that fentanyl screen was taken, things have to be taken into context. I'm sorry. And these cases are very fact-specific. And on the facts of this particular case, the facts here, there was not enough evidence to show that whatever he was using substantially interfered with his social functioning or that he'd lost control over the substance. There was no withdrawal. He was still attending school. He was an honor roll student. So those things have to be...
Do we know whether a non-addict who overdosed would experience withdrawal with Narcan?
There's no evidence, Judge. And I don't think it would be common knowledge.
I don't think it is. I don't know anything about it.
Looks like
There's
a
also...
common here anyway.
There's also a court form that this judge didn't use. She used an old form from 2012 that doesn't talk about any of the hearsay. It doesn't talk about any of the imminence. And here, the judge stayed the order. She stayed the order and then didn't stay the order. She kept going back and forth. And then
Well, there was a reason for that, because they couldn't find a place for the
yes, they couldn't find a place for him, but he was already engaged in treatment. He'd only been using marijuana and alcohol. The concern was that he was going to turn 18, and the clinicians wanted him substance-free. It wasn't, and in a legal context, there has to be a substance use disorder which places the juvenile at imminent risk for serious bodily harm. It's not stop all substances. That's not the standard. The standard isn't best interest. The standard isn't whether the clinician has solid evidence. She said, I have no evidence either way what he's doing. We just know that a clinician went to the house and they smelled marijuana.
We'll take a good look at the record once again.
Thank you very much. I appreciate your time.
Thank you for answering all of our questions. We appreciate it.
Thank you.
very much.
So we're going to take a 15-minute recess now, and we'll come back and hear the last two cases.
So to all rise, please.
Okay. So our next case is 2023-1160, MARINA VYRROS, is that correct? VYRROS, all right, versus the City of Boston.
Good morning, Your Honors. May it please the Court. I'm Robert Hernandez of the Mental Health Legal Advisors Committee, staff attorney, and with me is Omar Kazam, who's also an attorney.
Could you move the microphone a little closer to
Just going to ask you to move the microphone, because I was going to say the same thing, just close as you can. That's great.
Okay.
Thank you. Appreciate it.
Thank you.
All right, sir.
Okay. I'm here today representing MARINA VYRROS, the appellant, who is a permanent tenured teacher in the Boston public school system, who on January 27th, 2016, was terminated by the appellees effective January 26, 2016. This was an unlawful termination because she was never given notice of it. And under principles established by the courts, this court and other courts, notice was a necessary element for a proper termination of a tenured teacher. I ask that the court pay particular attention, or be particularly guided by its own prior decisions in the Framingham Housing versus Serfozo case, which this panel decided 2 years ago, and by the City of Worcester versus Civil Service Commission, a 2015 case. The first standing for the proposition that merely asserting that someone has resigned or abandoned the job is not sufficient when there is evidence that the individual in question did not abandon the job and wanted to keep the employment. And the second stands for the proposition that the city could not bypass her due process rights, which are established under Chapter 71, Section 42 of the general laws, procedures for dismissing teachers. They cannot avoid that merely by characterizing her as AWOL through policies which diverge from her due process rights.
So can I ask you a question? If I were to agree with your position that at the summary judgment stage, in the light most favorable to you, that we are accepting that this is a termination and that certain notice was due, right? That would call for what you're requesting is a reversal of summary judgment in favor of the school. You're also asking that summary judgment be entered in your favor. And when I look through that lens, then I say, in the light most favorable to the school. And I wonder, and I'm fast forwarding, but I wonder if there's still an issue of disputed fact as to whether her conduct, verbal or otherwise, constituted a termination or a resignation. Isn't that a disputed issue of material fact?
Respectfully, Your Honor, that's actually an issue of law, because we have,
so tell me why.
because on the one hand, we have a set of procedures established by statute whereby to dismiss a tenured teacher,
Right.
Certain steps have to be taken, including offering a summary of evidence, giving the opportunity to be heard, and at the time of dismissal, providing that notice sufficient then to
Right.
generate the
Right.
result that we seek, that would normally be. What occurred here was a bypass, an administrative bypass.
That's your point of view, right? That's your perception. So let's back it up. If a school teacher writes a letter and says, at 5 o'clock today, I resign,
Yep.
you would agree with me then, whether it's under the principles of waiver or otherwise, that they no longer have a property right in their employment, correct?
Correct.
And there's no responsibility on behalf of the school to send out a notice of why. There's no due process, right? You relinquish voluntarily your rights.
Yes.
Now, I understand that this is, in the light most favorable to you, the facts, is not the case. In fact, your client said, no, I'm coming back. I'm this close to coming back, and we're just trying to make some reasonable accommodations. I've read the briefs. I've read the appendixes. numerous times. But on the other hand, the school says, do this and that, or that, show up by January 26th, if you haven't, and if not, we'll consider your failure, your omission, to be the equivalent of a resignation. If we don't hear from you, if you don't file in the hub and get your doctor's report in this time period, second letter, January 26th, that's the equivalent to us of resignation. That's one of their many points and arguments. Isn't the issue then, what was it? Was it a resignation as argued by the school? Or was it a termination, and then there's a back and forth as to whether or not there was enough due process?
That if that were possible, and if such a jury question could be framed, that would be one thing. But the issues in the competing laws, the regulations, the procedures, the protocols versus the statute are incapable of resolution in the manner that Your Honor suggests, because either the school can do what it did, and let's accept that she did not do, that let's accept all the facts as they are there. The question is that then sufficient to eliminate the rights established? Is that a waiver of the rights set forth under Chapter 71, Section 42? That's a legal issue, not a question of fact. Does what occurred constitute a waiver? And I would urge that on the basis of the law, that it does not. The Framingham Housing Authority case would suggest that it does not. We have there a case of somebody who is absent periodically, is being told, you have to come back, this and that, and they deemed him to be AWOL, to have abandoned his job, and that wasn't enough. If in that case, or if in this case, the additional step of giving notice sufficient to trigger protections, we wouldn't be here. But that didn't occur.
So if the facts were different, let's say that your client, we have proof that she's moved to Hawaii and she's lived happily ever after. She's not coming back to the winters in Boston, right? We know that. Would the way that the school system treated her not showing up on January 27th be okay for them to say resignation because she didn't show up? Because we actually know that she didn't have any intent in coming back to cold New England.
The school has every right to terminate an employee who resigns. Okay, has every right. But any employee who does not show up for work is conducting themselves in such a behavior as to invoke justification issues under the statute provided for due process.
But can it be resignation?
The school can't create a resignation on its own. The school can't unilaterally decide, okay, we're going to consider X, Y, and Z.
So you don't think there is even a category deemed to have voluntarily resigned? You don't think there's anything like that? You can resign, and if you don't, you're being terminated?
Yes.
Okay. Let me ask you this. I was a little confused about this. Is there no collective bargaining agreement in place?
There is.
Does it say nothing about any of this? Why are we not, I understand that would be a matter for arbitration to do, but it has no bearing on what the rules are for when you can fire someone for not showing up, or?
We're not challenging those rules, Your Honor. We're just saying that when the decision is made to trigger that you can't ignore the fact that it was not, there's no signed paper, and therefore you have to have an opportunity to be heard and notice and an opportunity to be heard. That's what's lacking here. In this case, on the 27th, when they took their action, they gave her no notice, and she continued to believe that she was employed to a point where she could no longer contest that. If they had taken the simple step of providing her with notice, this would have been resolved through the arbitrator, whether she had resigned or not. That's the person in the position to understand the goings-on and so on, but that was not done. It was a very, very simple step that could have been taken that would have resolved this. Provide her with notice. And we're saying that that's fatal to this so-called termination. that because she didn't have notice, she was never able to contest or to justify her absences, as she tried to do informally through her emails. That opportunity to be heard, which is embodied in due process, just was not afforded to her. So we have a situation that, such as probably was foreseen to some degree by Justice Jackson in the Mullane case, when he suggested that the right to be heard has little reality or worth if it's not, if one is not informed of what is happening. And that's what we have here. We have a body of procedures set up that would protect her, that if they had been accepted, would have protected her, would have cost nothing. And when we look at the competing interests here, her interest in her job is certainly much more important than the administrative convenience of checking off a box terminated versus giving her that opportunity.
And this is just about the 30-day clock running, right? As far as whether or not she avails herself of arbitration. So this is just for purposes of my conversation right now, assume that I think you're right, okay? What happens? Summary judgment enters for you. What happens?
We have a wrongful termination. We have a wrongful termination, and we have the rights, the rights that would normally flow from that. In other words, the real question, the difficult question for this court is precisely that, Your Honor. What is the remedy here? Because that has not been resolved. And in some way, whatever the court decides here will help to resolve that.
I'm sorry, I don't understand why that's a hard question if you win. If you win, why isn't she simply reinstated as a teacher? They can discharge her if they want. They have to go through whatever the process is.
Yes.
I mean, is there something more complicated than that?
It need not be more complicated than that, Your Honor.
Okay.
But it could certainly be.
They may tell me it's more complicated than that.
Are there past wages that it might be due or things like that? Claims
Yes,
for all that?
exactly.
Oh, I see.
Exactly. I mean, I think that's if we look at the emergence of a tort of wrongful termination,
Yeah.
which has been evolving, which there's the Meehan case most recently, I think, in 2021, which suggests that as a matter of public policy, wrongful discharge may be compensated through traditional tort remedies.
But this procedurally, to me, is in an awkward place because the trial, the horse is out of the barn, the trial happened on all the other counts. This was just on a due process violation.
Right.
This was not on employee, discrimination because of mental illness or this is, count 3 is just due process.
Yes.
So you're saying it's wrongful termination. It's, okay, summary judgment, her due process rights were violated. Remedy, she's back as a school teacher?
Yes, I mean, the proper remedy for this form of a due process violation would be reinstatement. That would be the proper remedy. Now, whether there are equitable considerations or how that comes about, that's a separate issue. But the remedy for terminating you without telling you and then letting you waste months and lose your opportunity to challenge it in a meaningful way, that is something which is entitled to compensation under principles of Massachusetts
So
law.
why can't the school create a policy that says, and we tell you, hey, don't show up by this date and don't have these papers completely filed. We're telling you, we're going to interpret that as a resignation. Why can't the school do that?
Well, it could certainly do that if we look at its rational relationship to what the school wants to achieve through that. It can certainly set up clear policies but it needs to then track those policies and have a procedure wherein those policies don't eliminate the fundamental rights established through Chapter 71, Section 42. In other words, that property interest is established. You can't administratively say, okay, X, Y, and Z, it's gone. There has to be an opportunity before that act of termination, that act of dismissal, to be heard.
So you're saying it wasn't sufficient that she was informed that you will be considered to be irrevocably resigned from your position if you don't report to work by January, I think it was 26, right? Or whatever, 10/29. and/or ask for a leave and with the proper documentation.
She couldn't do much more with that than what she actually did, which is to promptly file a request for that.
And if that had said you will be terminated, would that be different?
Well, the act of termination itself is the critical act, not the threat of termination, Your Honor. That for purposes of clarity and conciseness as to when the rights accrue, it has to be at the time of the termination. Otherwise, the threat could be 6 months from now, aha, you waived your rights. So I respectfully urge that we be clear that it has to be, that it's the termination which is the critical event, not the flowering, the whatever.
Other questions? All right. I see your time is up, and you've answered all of our questions. Thank you very much.
Thank you.
Good morning, and may it please the court, my name is Mauricio Vaca on behalf of the City of Boston and Philip Brangiforti. This court should affirm the lower court's
I'm going to have to ask you to try and get that microphone closer
Okay.
to you as well. I don't know if it...
yank on it.
Is that as far as it'll go? Okay. Thank you.
This court should affirm the lower court finding that summary judgment be entered in the lower court defendants, the appellee's favor, and that due process was met, and that 7142, the statute in question here, was complied with, essentially. Because under 7142...
Isn't that essentially, isn't that part of the problem here?
It is, Your Honor. That is why the parties are here. But that essentially that the lower court essentially took the letter and assumed for the purposes of this analysis that it could be read as a termination letter. But it chose to say, well, termination and resignation is a factual dispute that has to go forward. So there was some decision by the court, essentially, on this due process issue. Under 7142, a teacher who claims she's been wrongfully terminated has the ability to seek the arbitration.
So do you concede that she was terminated?
No, Justice Rubin, we do not concede she was terminated.
Okay. If she was terminated, how was she notified such that she would know the 30-day period was running?
The letter is very clear, Your Honor. It's in the record. The first letter that went out was an incorrect letter. She gets that letter as an employee.
It says it'll be treated as a resignation. You keep saying to her, you haven't been terminated, you resigned. You haven't been terminated, you resigned. But she's supposed to go and arbitrate it while you're telling her you didn't terminate her. And now you come here and argue, oh, we did terminate her, she should have gone for the 30 days. How does that work?
Respectfully, Justice Rubin, we are not arguing that we did terminate her. We are arguing
Okay,
that
so if you didn't terminate her, then the 30 days never began running, or if they did, she didn't have any notice of it.
I think there are a couple issues here that the court needs to assess from a constitutional standpoint, from looking at this as a constitutional
And
matter.
statutory, but go ahead.
And statutory, but statutory would go into the arbitration realm in some form. Of course, the court can consider constitutional, standards, but in this particular case, in so doing, what was required was notice under Loudermill and an opportunity to respond.
When did she get notice that she was going to be terminated? Because I read that to say she's going to be treated as having voluntarily resigned, not terminated.
It's treated as she's irrevocably resigned.
Okay, but a resignation doesn't trigger an obligation to arbitrate. Presumably you'd say there's nothing to arbitrate, she just quit.
BPS at the time believed that this was an actual resignation, or Mr. Brangiforte, excuse me, believed that this was an actual resignation taking place. He notifies Ms. VYRROS that if by January 26, 2016, you don't show up to work, or you don't obtain a positive leave status, you will be irrevocably resigned as of that date.
Under what authority is the City of Boston able to deem something a voluntary resignation? Where's the authority for that?
It's a natural employee-employer relationship.
So if her teaching is inadequate, in your view, could you just send out a memo saying inadequate teaching will be treated as a voluntary resignation and avoid all of the, whatever it is, Section 42 procedures?
In that scenario, in your hypothetical, Justice Rubin, what the school would be doing is terminating for performance-based reasons. And if that's correct, then you would have to go through.
Well, in this case, you
and say
terminated
notice
for
of-
not submitting a medical letter.
In this case, it was not.
You think not submitting a medical letter is the same as resigning?
It was not that she didn't submit.
She
a
applied for the leave, didn't she? She just didn't get her medical letter in time.
She applied for, but the actual letter was, the actual letter said, by January 26th, come back or get a.
All right, what's the authority, never mind what the authority is for doing it. What authority, where in the law or whatever you have, regulations, does it say that you have the authority to deem whatever she did to be a voluntary resignation? Where would I look to see, oh, I see, certain things are going to be treated as voluntary resignation? Where would I find that?
There are cases that support that.
I'm not asking about cases. I'm asking about where in the city of Boston, the Boston Public Schools rules and regs, would she look to see, oh, I'm going to be voluntarily treated as voluntarily resigning? Where would she look for that?
She would have looked at the AWOL policy that's within the leave policy documents that she had at least constructive notice of.
This is the internal AWOL guideline?
No, Your Honor.
This is the superintendent's circular?
Yes, that is the superintendent circular that's published publicly October 23rd, 2015.
Okay, I'm going to read it to you. If an employee does not return from a leave of absence and does not request an extension, which isn't what happened here, but I'll keep going, the employee will be deemed AWOL. AWOL employees may be deemed to have voluntarily resigned from their position or may be subject to termination.
That's correct, Your Honor.
How are we supposed to know which it is? You just get to decide?
The letter would have advised her that she's being
Okay, but
considered-
what authority, where would I look to see when it's going to be one and when it's going to be the other?
Well, as an employer, you have the ability to say, well, you're performing badly or you're abusing this AWOL policy.
Where does it say that that's what where does it say that that's what the rule is for when it's a voluntary resignation versus termination? Because the circular says it could be one or the other.
I'm not
You
sure.
think you have free discretion to call anything one or the other?
Not, well, in this particular case, that this was, the facts are so that Mr. Brangiforti.
She
thought that
applied
this
for
was a
leave.
resignation.
She actually, when told by the deadline, applied for leave but didn't have a medical letter in. Should she know that that's a resignation just because you wrote it in a letter? What's your authority for saying not submitting your medical thing on time when you've told us you want to leave? We're going to treat you as having resigned.
There's a clear factual record in our appendix that lays out all the facts that point out that this was actually someone who was not coming back to work.
I'm not interested in whether she'd applied for a job elsewhere, which she should do given what appears to be the arbitrary nature of all of this. I'm just trying to figure out what authority you had to call this a voluntary resignation. And I don't understand how you can call something that isn't a resignation. Now, if someone totally doesn't show up, okay, maybe eventually you say, well, I guess they resigned, if they moved to Hawaii or whatever. But I don't understand how someone who is in talks with the school about what their return will or won't look like can be said to have voluntarily resigned, especially she applied for leave. Let me also read you the AWOL guidelines. I don't know what force of law any of this has. The superintendent's circular seems to be an email. I don't know what authority you have to promulgate rules through an email, but all right. The AWOL guidelines instruct the principal that after sending the AWOL letter, quote, if the teacher does not return to work or adequately justify his/her absences by the letter's response deadline, send a PS-03 to the Director of Human Capital Operations terminating the employee as AWOL. It doesn't say because she has resigned, it says terminating her. So didn't you terminate her under that policy?
No, Your Honor. The facts.
Was a PS-03 sent to the Director of Human Capital Operations?
I don't think that is in the appellate record, but I believe that might have happened.
Okay, so that's how you terminate an employee.
So let me back up for a moment. It doesn't seem like you're going to agree with Justice Rubin that she was terminated versus resigned. Okay. We're not going to get there in 15 minutes. But what I want to focus on is that in a motion for summary judgment, in the facts most favorable to the teacher, right? The judge in the Superior Court said, assuming it was a termination. I know you're fighting tooth and nail about that, but for right now, assume termination, but still summary judgment, you win. And you agree with that. So accepting the fact that you in fact terminated Miss, is it VYRROS? VYRROS?
Yes, Ms. VYRROS, yeah.
She said she didn't avail herself to arbitration. Right? And my question is, how would she avail herself from arbitration since she never got notice? Because would you agree with me that you never notified her that she was in fact terminated?
The only, I would agree in the sense that the only letter that went out that said that there was something happening, and I'm looking at this from a constitutional due process standard because we're really in constitutional.
I'm looking at it for a motion from summary judgment standard, right?
Okay.
So
Yeah, so.
we've got to, much as you don't like it, facts most favorable to the teacher, she was terminated. You agree with me that you never sent her a notice telling her, no, it wasn't irrevocable resignation, we're really terminating you, for the clock to start to tick.
Even if that was the case, and agreeing with your hypothetical there, Your Honor,
No,
Justice
no,
Walsh.
this case, this is this case. Do you agree with me that you never sent her a notice saying you are terminated?
That is not on the record. That's correct. That's not on the record.
So that's when the clock starts to tick, right? For the 30 days of arbitration. She didn't get that. She got resignation, and guess what resignation gets for due process, right? 0, because you voluntarily relinquished it. You can stand on that island of voluntary relinquishment, but in a motion for summary judgment, the facts in this case, you'd be on a teeny island, but so be it. But you've got to make a winning argument that you're entitled to summary judgment even with termination. And I don't see how you win when you never gave her notice of termination. So tell me how you win when you didn't give her notice of termination.
So the manner in which we win is because what this court is actually assessing at this point in time is for what was claimed to be a constitutional violation. So what this court has to do is assess the 14th Amendment, whether or not under the standards that have been espoused by the Supreme Court, like in Loudermill, for example, whether or not the notice of the proposed action.
And the SJC and this court.
Yes, Your Honor.
So tell me how you win. Is your argument that you gave her due process?
That is correct. This was due process.
But before, what notice of termination did you give her? Isn't that a fundamental element of due process? Is what the heck happened to me? So I can maybe exercise my rights.
Well, the city of Boston would say that the notice saying that you're going to be irrevocably resigned can be reasonably read as someone who's claiming they're wrongfully terminated for these facts as a divestment of employment in some way.
If I get a
but by
letter
the
saying that I'm
Employees Acts.
irrevocably resigning my position, I should interpret that as I just got fired. I have to go to arbitration, because at arbitration, the city of Boston's going to say, you didn't get fired, you resigned.
I mean, I don't see, as someone who's claiming under pure statutory, now reading the statute, pure statutory interpretation, it says someone who's claiming they've been wrongfully terminated. Now, that's something that the arbitrator can subsequently address, but she did not act within the 30 days.
Because the clock starts to tick when she gets notice of what you're doing. You didn't tell her what you were doing. You told her what she did. You didn't tell her what you were doing. You were firing her.
along with the facts that there's a policy that she should have at least constructively been aware of that affects her interests, that are drafted in consideration of the Boston Teachers Union.
Yeah, I noticed that. That's not English, so I don't know what it means, in consideration of. Is it drafted pursuant to the collective bargaining agreement? Is it drafted by request of the union? What does in consideration of mean?
I don't think the record explains that, Your Honor.
Okay, but you just used it to justify something. What does it mean?
I was getting to my point,
Okay.
Justice Rubin, that
I mean, I'm sorry to be
as
so
an employee-
like aggressive about this, and I know you're just arguing the case. So, but
as an employee, you should have a duty to pride yourself of the things that might consider you or affect you negatively as an employee, right? So as an employee, reading the policy, seeing, okay, if I'm absent without leave for 3 months, like, you know, I could be considered irrevocably resigned.
you call that a policy? That's in the superintendent's circular?
That is correct.
Are those binding rules somehow? How are they promulgated?
They are drafted, well, it's not on the record either, but they are drafted and promulgated, I believe, by the superintendent's office.
The superintendent can just make up all kinds of rules? Is that true?
No, I don't believe that's true, Your Honor.
I wouldn't think so.
Yeah, but in this case, there's such thing as divestment of your property interests, and I think in our brief we've cited that at length. But if you're going to look at it, if we're in resignation land, no worries. But if we're in termination land, Loudermill, notice of proposed actions, reasonably reading that letter to say, okay, well, there's something's happening here. I have to act. I have to do something. But in this case, that didn't happen.
Do you agree with your brother that if this case is going to be decided on summary judgment for one side or another? So in other words, I don't know what's going to happen, but if you lose and we reverse the summary judgment entered on the city's behalf, does that automatically mean that summary judgment should enter for Ms. VYRROS?
No, Your Honor. I would say that if this court finds that there is a factual dispute that's needed in order, even though it's assessing for a constitutional notice of the proposed action matter, if this court finds that there's some factual dispute, that they would have to go back.
And would you say that the question, is this termination or voluntary resignation, is a legal question?
I'd say no, it's not a legal question. It's a factual question.
Well, one of them triggers a whole bunch of protections under a statute, and the other one doesn't.
That's correct, but the employer in this case, BPS, took based on what was going on and based on the fact that she'd been AWOL for 2 months without contacting her supervisor.
I'm asking whether that's a legal question. You've set out what the criteria are for something you call AWOL, although you then say you may be subject to termination or voluntary resignation, right? But figuring out which box it's in, isn't that a legal question?
Yes, I mean, that would be a legal question, yeah. But I'd say there's clearly a factual dispute in the record.
And you don't have anything other than this one circular that talks about deemed to have voluntarily resigned. There's no numbered policy somewhere or promulgated regulation or something for which things are deemed voluntary resignations versus treated as terminations.
It's cited in a footnote, section 31, I'm sorry, chapter 31, section 38 of the civil service laws, at least tells you that the legislature views AWOL or being absent as a resignation versus a termination. That's something that's separate from, in the employee-employer context. That's something that's common, that someone leaves job, abandons their job, and so you kind of assume that they've been terminated. There was some notice provided. Hey, look, you've been absent without leave for X amount of time. You haven't come back. You're not coming back. Come back by that certain time, and I think that comports with the constitutional standards under Loudermill.
That statute is in a footnote in your brief?
Yes.
Okay. I can find it then.
Cited.
No, you don't have to. I can. I mean, I wrote down what he said. I can find it.
You're over. I'm just going to check to make sure that nobody else has further questions. So Justice Walsh, does any more questions? How about you? No. I want to thank you for answering all of our questions. We had to press a few points because we're trying to understand exactly what all the issues are, and we appreciate your candor in answering them, both of you, answering all of our questions. It's very helpful for us.
I rest on my brief. Thanks.
All right, we're now going to get to our last case on the list today, which is case number 2023-0917, Barbara Clark versus KRISTIAN TALVITIE or TALVITIE. I'm not sure. I'll find out when you come here and tell me how to pronounce your client's name. Okay, so good afternoon.
Afternoon. Your Honors, Sandy Derlin, Warner, Federico, and Ryan in Boston on behalf of KRISTIAN TALVITIE.
TALVITIE. Okay, thank you.
I have some remarks to set the framework for the argument. To start, before I will jump in my argument, this is a divorce-related contempt where the parties disagreed over the application of a formula in a judgment that, by agreement, the divorce judgment, as to the calculation of alimony and the applicable definition of income which is used in that calculation. Now, the judge entered a clarifying order in his contempt judgment after determining that that language was ambiguous. And I think that his decision was based more on his inclinations as opposed to the party's intent or the language itself.
Do you mean more on the fact that there was a pending complaint for modification?
I'm sorry, Your Honor?
Isn't there not a pending complaint for modification when you say you think the judge was?
There is a pending modification, yes, and that is scheduled for trial in January of next year.
2025, yeah.
And, but my view is that the language of the definition of income, earned income, in the agreement is very broad and very clear and addresses a myriad of circumstances, including the one which was presented to the judge. And I don't think there was, and my argument is that there was no basis for the clarifying order. Now, I don't know if Your Honors have any questions before I begin specific the points I'd like to make. But that definition of earned income, as I said, addressed a number of different forms of income and circumstances. The judgment included forms of income which were not relevant or even germane to Mr. Talvitie's circumstances at the time of the divorce. There's the language talks about calculating self-employment income. It talks about stock options, none of which were applicable at the time of the divorce. It also indicates how to treat equity-based compensation, which also was a component at the time, and provided for conditions, the largest condition being before that income can be included in the calculation, it has to be considered earned income through the triggering event of cash generation. Yeah. That's right in the agreement. And that was part and parcel ignored by the judge in his decision. And while he suggested that he intended to make findings as to the party's intent, he didn't. There really were no findings as to the party's intent. He certainly relied on experts, which he's permitted to do, but not in the dispositive way that he did here. You know, he looked to the experts. He found one expert's opinion was more persuasive, and that then governed his decision. But there are no findings as to...
That is, would be any problem with that? In other words, if we were to conclude that the term earned income is ambiguous,
ambiguous.
If we were to, hypothetically, right, that it is ambiguous, then there would be nothing wrong with the judge having listened to two experts and making a decision as to which definition he wanted to adopt with respect to earned income, correct?
Oh, no, I mean, yes.
Yeah,
I mean,
okay, all right.
there's nothing wrong with the judge hearing from expert as a means of, highlighting or clarifying some issues. But I think that has to be done in concert with findings regarding the party's intent insofar as this ambiguous, if found, provision is concerned. And that wasn't done here. The judgment made a sort of a summary conclusion that, well, father, husband is saying one thing, wife is saying another. It must be ambiguous. And then that led to his clarifying order.
When you sell stock that you already own, what do you realize?
You realize, well, either income or loss.
Capital gain or capital loss?
Capital gain or capital loss.
So you don't realize, ordinarily we wouldn't talk about the sale of stock as realizing income. We talk about it as, the way this is written is almost incomprehensible to me, because we don't talk about realizing income, at least as an ordinary term of accounting, right? We talk about realizing gain, realizing loss, but it says realizing income.
Right.
Okay, so if I had to say when income is realized, the most natural reading of that for me, leaving aside, we're going to get to the cash part, the most natural reading of that to me is when it's reported on your W-2, right? That's when you get income. Okay. It also says, or deferred on a cash basis as opposed to merely a taxable event.
Right.
Okay, that's meaningless to me. On a cash basis versus an accrual basis are two methods of accounting. Something is deferred if you use an accrual basis. I don't even know what deferred on a cash basis means. It's incomprehensible to me. Do you know what it means?
Deferred on a cash basis?
That's what it says. It says, yes, or deferred on a cash basis.
Well, I based on what this agreement says, I think I know what the agreement says, and I think it's clear. Here, the distinction between amount realized, which conveys a taxable income.
Yeah, okay.
That is different from the agreement then going on to say, except it must be in cash. It cannot be just...
I'm not getting to the cash part yet. I'm still in the first line of this thing. Just trying to figure out what it's supposed to mean. And I get to deferred on a cash basis, and frankly, I'm lost. I understand what deferred income is. I understand that whatever a company can have deferred income because they, instead of using a qualified plan, they have some internal system and it's deferred income. So it's placed into this, it's like an IRA or whatever, but I guess it's pre-tax.
I follow.
I don't know what it means to say on a cash basis because we're talking about equity-based compensation. So
I can only answer your question, Justice Rubin, in the context of this agreement, and that has to include this cash qualifier.
Okay, so now let's go down below. If I'm reading this the most naturally way, income is actually realized means when it's on your W-2. Then it says, including. So now we're going to look at 3 examples it gives us of what they say is when income is actually realized or deferred on a cash basis. Including gross pre-tax proceeds as a result of the release of restricted stock. Okay, yes, I see that so far. Income is realized when you get, well, I don't know what pre-tax proceeds are. The stock is treated as income on a W-2. But then in parentheses it says, but only when cash is realized from the event. Okay, that is not when the income is actually realized. Cash is realized from the event at the time, I guess, although of course you could have a loss. Maybe, well, I guess cash is still realized, whatever whatever you get out of the sale of it years later or whenever. Capital gain is realized, capital loss is realized, but it's already been reported as income. So if I read this, it seems to me, I have a contradiction. I don't know if I want to call it an ambiguity. First, it sets a definition out, and then it gives examples that are included in it, and the very first example is not the same thing at all. All right, now I'm the judge. I actually am a judge. What am I? I'm not the judge who ruled on it. What am I supposed to do when an example as including is in fact not included in the language that preceded it? Do you see what I'm saying? Like if there were no includings, we'd just say probably just income on the W-2.
But for the parenthetical
But it's not a qualification. It's listed as including.
Well, it makes the distinction, the release of the stock. The release of the stock occurs when it vests. And at that, it is at that point that it is treated as realized income and is then taxable. And it is typically part of the calculation. By the way, that was what was the case with the restricted stock that was received as a bonus, because that immediately vests and since it is a bonus under the agreement, it is factored immediately into the alimony calculation. But the equity-based restricted stock is different because it vests over time. It should be subject to, it is and should be permitted to be subject to these blackout dates, these holdback requirements for the husband as a consequence of his position. But before that equity-based stock can be included in the alimony calculation as earned income, it must be income realized, and that requires a triggering event of cash or a triggering
No, we just said income is actually realized when it's on a W-2.
No, there's a difference in this agreement between when it's taxable and when it's cashed. And that is the distinction between the performance-based RSUs and the equity-based RSUs. And it's also consistent with what happened at the time the parties were divorced, because at that time he worked for a privately held company, and his equity interests weren't as fungible as they would be now that he's working for a public.
There had to be a liquidity event.
There would have to be a liquidity
And he
event.
described that in his testimony. I don't know if this is right or wrong, but in his testimony he said that's when it's turned into cash.
Right. Exactly.
So
And
can I just make sure I'm clear in your argument? Because without the in-depth understanding of financial compensation in PSUs and RSUs, and I'm doing my best here to follow it, ordinarily earned income when the bell rings on your 1040, right? In this instance, you're saying even if he had to pay taxes on the value of this whatever.
restricted stock. Yeah.
Stock, thank you. I thought I heard that in the side of my, that it doesn't matter that he has to pay taxes. It's not until that money actually is taken and he holds on to it. So in other words, if he keeps it in abeyance, pays taxes on it, he doesn't have to split it with the wife.
That's what the agreement says.
But that's your argument, right?
Because that's what the agreement says, and it's clear there. And it's also, again, it's consistent with what was going on at the time the agreement was drafted, okay? That definition is very broad. It's meant to encompass a slew of different scenarios, one of which is the equity-based compensation. And that equity-based compensation says, but only when cash is realized from the event. You don't get cash when the restricted stock vests.
When it
his
vests,
tax.
does the company sell some of it to withhold taxes?
In his case, they do a holdback and they do sell to.
So some of his stock is sold at the moment of vesting so that he can pay the taxes on it?
Correct.
And that counts as income, you agree?
That would be income, although he's not receiving the cash for it.
I agree he's not, but he's going to be taxed.
You're right. No, you're right. That is an event. That's a triggering event. But the net of that amount is not cashed, and therefore, under the definition, it is not included. Now, the judge certainly took issue with that. He felt it, in so many words, he thought that was crazy. But that's what the agreement says.
It is crazy, but that doesn't mean it isn't what it says.
Exactly. I mean, that's exactly the point. I mean, part and parcel, that's really where this all boils down. I'm almost done. Unless you have any further questions, I'll rely on my brief.
Thank you very much.
Thanks.
Good afternoon. May it please the court, my name is Rachel Sohn on behalf of Barbara Clark. I'm here with my associate Alana Monke, who has assisted in briefing the matter. And for the court's edification, it's TALVITIE.
TALVITIE.
TALVITIE. Finnish. It's true, it's Finnish. The primary question of contention, issue of contention in the Mr. Talvitie's appeal is whether or not this term, cash realized, is ambiguous. Obviously, Judge Barber found that it was. What's interesting is we obviously took the different position at the time of the trial. It was a contempt trial, so the standard being on contempt, whether or not there's a clear and unequivocal command and whether or not the defendant has willfully disobeyed same. That was our position, that there was a clear and unequivocal command. But the judge's findings and certainly our respective arguments and the experts' testimony on the issue of cash realized and whether it's ambiguous and what it means, all of the differing interpretations of those couple of words, lend itself to the clear indication that these are ambiguous terms, that cash realized is an ambiguous term. I believe that Mr. Talvitie has an over-reliance on the term cash as it indicates like a green money or a ledger in a bank account, rather than what it actually is, which is an asset which is readily convertible to cash.
Wouldn't you write cash or cash equivalents if you wanted to include liquid investments?
Cash or cash equivalents would be something different than something readily convertible to cash. Cash or cash equivalents, to me, indicates something that is more akin to something green or a balance in a bank account. Cash realized would mean something closer to what is readily convertible to cash.
How can stock be cash? It isn't.
Well, as Your Honor pointed out, and I find this very an important point, having lived through this for so many years, and in particular this particular contempt trial. At the time of the contempt trial, in fact, Mr. Talvitie took the position that those stock shares sold to satisfy tax withholding obligations as it was a requirement of his employment obligation with PTC, were actually not income, was not cash. It was never cash. He took the position that those stock shares that were withheld for the purpose of satisfaction.
Withheld and sold so taxes could be paid.
That's exactly right. And that was my position. His position was that they were retired. Retired being, in his view, something different than
He's
cash
paying
realized.
tax on that money, so.
I agree with you. I agree with you, and we took that position. Unfortunately, Mr. Talvitie took the opposite position, that there was no support due on even those shares of stock sold to pay taxes because they were retired.
The positions you both took aren't really, I mean, unless you're arguing judicial estoppel, I'm just interested in what this means now, right? We have to figure out what it means.
And that's exactly it. And that's
Can I
exactly
just back up for a moment, because when we look at, and I agree, the intent of the parties, right? We're going back to May not be a smart idea to sign this, but the intent of the parties. This is a sophisticated financial person, right? Who is getting, instead of, we'll call traditional, this is what your salary is, these are your benefits, right? These stocks. So if every time he got a job and had X stocks, they might have been worth 10 times that in 5 years, right? And so what your position is that he has to pay whatever the factor is over to the wife now, instead of holding on to these stocks, which he doesn't have. He's got them, but he's not, he doesn't have them. But if he waited 10 years and they were 10 times the amount, or 5 years and 10 times the amount, and then went to another job and they gave him a check, the wife would have to be given her cut of that, correct? I mean, it's in essence forcing him at the time he gets this benefit to give her the value now when it's stocks. Well, what if in 5 years it's worth nothing? So that means first he has to give the wife a third of, I'm going to make up of $1 million, but then in 5 years these PSUs and RSUs are without any value?
I thought your position was it was only when it became unrestricted.
That's right, yeah.
So that he can sell, or he could even probably give her the stock if she'd accept it, but he can sell that portion of the stock for whatever it's worth that day, and that's how much he owes her, a third of the stock.
But he doesn't have to sell it. In other words, it's his benefit until he does something to sell it, right?
So there's a number of different questions being asked from my viewpoint, right?
Okay, no, take her question.
And even your question, I think you're asking actually 3 or 4 different questions in the one,
It's possible.
Yeah,
Very possible.
which is to say that on what amount does she receive the support, right? And the agreement says upon the release of the RSUs, and the Jones case actually is really apt in saying these cases are not easy. Executive comp is hard. You have to really endeavor to try to pull every piece, and certainly that was done here. There was an effort to be comprehensive in this definition of earned income, which is different than that agreement dealt with in the Jones matter, where it's just bonuses, right? Here, it's much more comprehensive, but yet still faced with the difficulties of all the different types of executive comp. Your Honor asked a question about when the timing, sort of, but also the amount. The timing is upon the release. So with RSUs in particular, when RSUs vest, they immediately release to the employee and flow through to a pay stub and then to that person's W-2. Different than, for instance, options. Options, once those vest, you have the option to strike or exercise the option and then buy at a certain price. You can choose not to, or you can choose to exercise it and sell, or you can choose to exercise and hold. All different than RSUs. Here, RSUs are released, immediately becomes stock that goes to his E-Trade account with some amounts withheld, sold, and paid to the IRS and the DOR. He has those stocks in his E-Trade account readily available to sell to satisfy the alimony obligation. And I should note for your honors that it is an unallocated support obligation. There are 4 minor children that are also benefiting from this support. It is, in essence, a combined, meshed child support and alimony obligation, which is important to note because it's more than just the wife's needs. It's a familial need, which goes to the ridiculousness of, well, $142,000 a year on this family of 5. That makes no sense, right? Which is what it is that the husband's position was his obligation in that particular year of the contempt.
Can I ask you a question about the text? I mean, I just keep looking at this text, although I can see different ways to construe it different ways. If there had been a comma here or there, it might mean something quite different actually, but all right. Including pre-tax proceeds as a result of the release of restricted stock. The release of restricted stock. What does that mean?
It's the release of the restriction. So I think...
So meaning he owns it, he's paid income tax on it,
yes.
But the pre-tax proceeds only occur as a result of the release, even though he's paid taxes on them, could be 2 years before. Maybe they're locked up for 5 years, whatever.
That's not what happens with RSUs. RSUs, you don't pay taxes on until they're released, and at the time of the release.
I see. Okay. Down below, I hadn't noticed this. Exercised, qualified, and well, it says so including, and the gross pre-tax proceeds of all other forms of company ownership-based incentives from the employer, comma, doesn't say including, so I don't know, exercised, qualified, and non-qualified stock options and stock grants in the year income is recognized. Is this a stock grant or is this a released restricted stock?
Right. The two, again, the agreement is meant to encompass all forms of employee compensation, whether it's through a K-1. In particular, as going back to your question, one of your questions is there are times where someone is taxed on a K-1 for income which they don't have. It goes somewhere else, right? And so this is meant to be fair, right? It's ambiguous. It's ambiguous, but the drafting of it is meant to be fair so that if he doesn't actually get the benefit of money, if he doesn't have something that's readily convertible to cash, it's not fair for him to have to pay 32.5% of it. But if he gets the stock, it's in his E-Trade account, and it's readily convertible to cash, it's not fair for him to have that pile up that he can take a margin loan on, he can take a mortgage against, he can readily convert it to cash in other ways and have the benefit of it, and Ms. Clark has nor her children benefit from whatsoever.
And it makes no difference as far as, I'm sorry to interrupt, as far as you're concerned that in 5 years or 6 years, to Judge Walsh's point, that particular stock could be zero or it could be worth $5 million more. Because the point is that that's the sliding scale, that's unpredictable, and you have to do it at the time that it's actually available to him and of course, also indicated on the W-2.
Right, and that goes again to another question, which is, should she ride the benefit or risk? There are agreements in divorce. There are agreements where you account for, we agree, husband's in the best position to know whether we should ride the risk on this, and so he's going to decide when to sell. That's not this case. In this case, he can choose to hold on to the money but pay support, or hold on to the stock but to pay support off of other assets. It's just that my client doesn't have to bear the risk or benefit, for that matter, of holding onto the stock. When she receives her support, she could buy PTC stock if she felt like this is a good bet because it's on the public market. She could do that. But this agreement isn't like one of those where we're choosing to put one person in charge of the risk.
No, this is very helpful. My question, I guess, is the ambiguity the earned income language, or is it the cash realized language?
The ambiguity is as to the cash realized language, and in this case, as applied here, that is the earned income, right? Because Mr. Talvitie's earned income is 6 plus, 7 plus, it goes on, it's going to keep raising, $1 million of RSUs, which are the particular issue of this.
But you don't say these are stock grants, right? We're not looking at that stock grant and the year income is recognized.
These are RSUs and PSUs, akin to a stock grant, and in fact, it is stock. If you look, and so
what does PSU stand for?
Performance stock units, which is similar but different to a restricted stock unit, a performance stock unit.
You're calling it a stock unit, but he doesn't have to pay tax on it until it's stock, right?
He pays tax on it before it becomes stock, but as it's released.
Okay.
As it's released. So it's a one-and-done situation, different than...
I don't understand. What can he do with a PSU? He can trade it for a share?
No, it is essentially an abstract until that event comes to fruition, whether it be by vesting or by performance of the company.
Right, so when before it vests, you're not claiming any of it.
That's right.
It's when it vests.
That's right.
What does he have when it vests?
When it vests, it is released and becomes stock.
But it's not a stock grant in your view.
I'm not sure that my view is necessarily important here.
There's different language. There isn't this only when cash is realized from the event with stock grants. That's quite clear, and the year income is recognized.
And so...
But no one has said, I don't want to no one has argued that, so I don't want to.
No, I think the better, maybe I'm wrong and you'll correct me, but I think the better argument here is that this language is ambiguous. And so Judge Barber was left, the court was left with, what does it mean? And then in looking at what it means, the judge then looked at, well, what is justice? What did the parties intend to do here? And therefore, what
I don't see any, and what's the evidence of what the parties intended to do? Experts don't know anything about what they intended to do. You didn't talk to drafts people, you didn't look at earlier drafts of it to figure out what they had in mind, or, right? I mean, it's only, I mean, the experts aren't telling us anything about intent, are they?
Respectfully, no. The experts can't necessarily testify to that. They can testify to the various iterations of calculations based upon what their opinion
But I don't think there's a dispute about the calculations.
Where did the intent come from the overall, just from the agreement itself?
Yes, and the intent is from the overall agreement itself, and if you look to page 5, paragraph 15 of the court's judgment, it specifically outlines that at the time the parties were divorced, Mr. TALVITIE worked for a private company. He couldn't sell the RSUs that he had from SingSort, and so when he left, there was nothing left and no income was realized there. And at the time of the drafting, Mr. TALVITIE had gone from one company, I'm forgetting.
A Scorp or something.
It also starts with an S, Sonosoft or something like that. Then at the time of the divorce, he was working at SingSort. Both of these were private companies with similar compensation structures where there's salary, bonus, and equity grants of some sort. But the equity grants are essentially meaningless or worthless until essentially that company that he works for is acquired or sold to another company. That's that liquidity event that he was testifying to. So, and that didn't happen here. And so with SingSort, the RSUs went away. And so here, the judge aptly noted in paragraph 15, page 5, that at the time of the drafting of this, there was this issue that the RSUs were worth nothing. But he had previously worked for PTC, and there was testimony on the fact that every year he would cash in the stock, or the RSUs, which became stock, and as it became stock, he would sell it, and they would use that money that resulted from the sale of the stock, which had been RSUs, towards their marital enterprise, towards the support of both his wife and their 4 children. There was a long history of that, and there's testimony to that as well, Your Honors.
So the idea being that would carry forward.
That would carry forward.
Even though it's worth maybe now a lot more money, but if it's worth a lot more money, that's really part of what the complaint for modification would be about, not about interpreting what was foreseen or what the intent of the parties at the time that they signed this agreement. Is that fair to say?
My position is a little different, which is to say that the tiered support amounts, with the lowest being on these amounts over $1 million being at 10%.
They had thought about a future where there's a lot more.
They thought about a future of a much larger income, but they gave credit to the fact that that was an after-divorce situation and made it a much lesser support amount.
The judge ruled or concluded that this cash is realized from the event referred only to the mechanism that was in place at the company he was at prior to the divorce, and that the parties had not foreseen or thought about or in this clause meant to cover the new type of restricted stock he was getting.
No, I think the judge actually said the opposite, actually. I think the judge recognized in his findings that he had worked for this company before, they had sold the stock to support their marital enterprise, and that at the time of the divorce, he was working at a private company that he couldn't sell the
That's
RSUs.
exactly right. He read this, I think, as being about that private company, in which case cash is realized from the event only at a liquidity event, and therefore that's when the money is due, at the liquidity event. Would we describe what happened at the private company as the release of restricted stock? Is that what happens at a liquidity event in that private company?
No, actually. I think the release happens prior to the liquidity event.
That release, is that a taxable event?
No. It's not. It's a book event. It happens on a ledger. And it does depend on the company. Again, going back to the fact that these cases of executive compensation are incredibly case-specific, very detailed, and often involved professionals, executives who
So
change
cash is when
roles.
it shows up on his W-2 in the case of the private company.
No,
Okay, so this one.
not necessarily.
When does it show up on his W-2? It's got to be either when it's granted to him or when there's a liquidity event.
That's right, and I can't answer the specific question that you're asking, which is, do the RSUs end up on his W-2?
Or K-1, whatever, I don't know how the place is structured. I just mean wind up on his 1040, right?
He certainly, we can guarantee, is getting taxed on it at some point if he's
I
getting the money.
agree, but if it's earned when it's taxed, I'm asking, when is it taxed?
From a private company?
Yeah.
At that time of the liquidity event, and not
Liquidity,
prior.
okay.
Yes, yes.
Can I ask you, I know you're
No, go ahead.
way over. What do you understand the phrase "on a cash basis" in the first parenthetical to modify?
You know, it's so interesting, as I heard you questioning Attorney Durland about that particular phraseology, because I have lived with this language for so long, and I can't answer you.
It might make sense if it modified both actually realized or deferred, and then it would say, there's no comma there, but if there were, it would be on a cash basis. That would, I think, support your brother's argument. That is, deferred or earned income on a cash basis.
I don't know, and I can't answer it. What I can say is that I do not believe that that particular phraseology, cash basis, is of import in this particular set of circumstances. This particular set of circumstances is very specific to RSUs released and cash realized, which is an ambiguous phrase or set of words in this particular case, which then needed to be clarified, and the court did.
What's the best evidence or case you have for treating stock as cash? Your theory of if it's readily convertible to money, it's cash. Is there any place anyone else has ever said that?
The case of Commonwealth v. Porter, 462 Mass. 724, cited in my brief at page 20, stands for the proposition, or it holds cash assets are the equivalent of liquid assets because they can be quickly and easily converted to cash, considering liquid assets as assets reasonably converted to cash.
And what are they construing there? A statute or a contract? Or?
That's a tax case. Oh, I'm sorry. I don't specifically recall, but that is the proposition I believe that Your Honor, looking for. And where these particular stock units were held in an E-Trade account and available to be sold. They were readily available to be turned into cash. There's nothing further.
Well, I think we can thank you very much, both of you, for giving us a little bit of a tutorial on executive compensation, and we appreciate it, and understand that it's a difficult case, and we'll take it under advisement, and we'll get back to you as soon as we can.
Thank you
and
very
thank you
much.
for answering all of our questions, because
Thank
that was very helpful as well. All done. Court will stand in recess.
All rise, please.